Ladies and gentlemen, distinguished guests, and esteemed participants, we stand on the zenith of this momentous occasion, the finals of the National Moot Court Competition of Xavier Law School, Exine University, Bhubaneswar, in collaboration with the Competition Commission of India. The journey has been remarkable so far, and now the responsibility of determining the ultimate winner rests with our esteemed panel of judges. It is an absolute honor to be adjudicated by two prominent judges, where everyone is a specialist in their practice area.
We extend a warm welcome to our distinguished judges. Their intellect, judgment, and commitment to excellence have been instrumental in showcasing their commitment towards legal acting.
First, we would like to introduce Dr. Vidyadhar Machi. Dr. Machi is an advisor in economics and head combinations of Mergers and Acquisition Division, Competition Commission of India. Before that, Sir was director and joint director at the Competition Commission of India, handling antitrust matters. Sir was also faculty member of the Indian Institute of Foreign Trade, Institute of Chartered Accountants of India, and Government Autonomous College, Fulbani, Odisha, in the area of economics, and also served in the National Sample Survey Office, Government of India. We are indeed obliged to have your expertise and vast knowledge to enrich us.
It is a profound honor that to introduce Mrs. Pamira, Senior Advocate at the High Court of Odisha. Influenced by legal contributions of her grandfather and father, Ma'am had developed great interest in legal studies since childhood. Ma'am is a part of Odisha's first 5-year law experiment under the Madhusudan Law College. Ma'am was awarded the Nani Palkiwala Memorial Trust Gold Medal, and Ma'am counsels many public sector undertakings like NALCO, OMC, amongst others. Ma'am has also been awarded a gold medal for the best advocate in the year 2015. In the year 2023, Ma'am was designated as a senior advocate at the age of 43. Today, she is the only female senior advocate in the Odisha High Court. We are truly obliged to have you both here with us today.
We now kindly request the court masters to advance with the proceedings. Thank you.
Good morning to one and all present here. I am Shreya Kumari, court master for today's courtroom session, along with the timekeeper, Ms. Manjot Kaur. For the convenience of the honorable judges, the time bifurcation as provided by the teams are provided on your desk. You may kindly refer the same. With the due permission of the honorable judges, the court master seeks permission to address the courtroom rules. This is the final round for the National Moot Court Competition 2024 in collaboration with the Competition Commission of India, whereby each team has been allotted a maximum of 45 minutes. The time left will be shown in the intervals of 15 minutes, 5 minutes, 1 minute, and time out. The team in any case shall not reveal the name of the university, the courses they are enrolled in, and in disclosure of the same, the said team shall be debarred. The teams have to abide by the time bifurcation as provided by them and has to maintain the courtroom decorum at all times. And in exceeding the time limit, there will be a deduction of 2 marks every minute as per the discretion of the organizing committee. They have to maintain the discrepancy. They have to maintain the courtroom decorum at all times, and in case of any discrepancy, the decision taken up by the organizing committee shall be final and binding. Now, I would like to request Speaker 1 on behalf of the appellant to kindly approach the dais and start with the pleading. Speaker 1, they requested to approach the dais. Court is in session now. The counsel, please. Your Lordship, in your leadership, the Council seeks permission to collectively address the bench as your Lordship and your leadership. Much obliged to your Lordship and your leadership. I am Council number 1, here on behalf of the applicants. I am accompanied here by my co-counsel, Council number 2, and together we will be representing the interests of our client, who in the present case is the Medical OTT Association. While I shall be dealing with the first and second issue, my co-counsel shall deal with the third and fourth issue that have been identified by this honorable end judge. If the tribunal is well versed with the facts of the case, the council seeks permission to move towards the substantive parts of the submissions. Much obliged to Lordship and your leadership. For the convenience of the tribunal, the council shall delineate a brief structure of what her arguments are going to look like. With respect to the first issue, which is whether the CCM has erred in dismissing the allegation of tying and leveraging against Sahara.com by making use of its position of dominance in the e-commerce marketplace as well as the OTT services marketplace, we make two submissions. Firstly, that Sahara.com has in fact leveraged its position in the e-commerce marketplace. And secondly, that Sahara.com has also abused its dominant position in the OTT services marketplace in order to tie the services of unrelated relevant markets. Our submission with respect to the second issue is primarily that Sahara.com has indulged in abusive conduct in the form of the arrangement of time, as well as in the form of imposition of unfair conditions in terms of prices as well as contractual terms that it has imposed upon its customers. Now, with respect to the first submission of my first issue, it is my humble submission on behalf of the appellants that the CCM has erred in dismissing the allegations leveled against Sahara. This is because the application that had been filed with the CCM had been filed under Section 26(1) of the Competition Act. This section requires the CCM to make a preliminary investigation and form a prima facie opinion of whether or not an allegation of abuse is maintainable against the enterprise. In this context, it is submitted that the CCM did not, in fact, make a prima facie opinion based on a preliminary investigation. It is also important to note here that the CCM is not required to delve into the merits of the case or any evidence that is adduced by the parties at this stage of forming a prima facie opinion. And insofar as the CCM fails to fulfill its duty in constituting an opinion based on the facts of the case as presented by the informant, it has erred in its decision to dismiss the allegation. Proceeding to my second submission, which is that Sahara.com has abused its position in e-commerce marketplace by by making use of its dominance in the said market, and also by making use of its dominance in the other market, which is more specifically the OTT services streaming market. We submit to you, or we prove to you this argument by way of 4-pronged submissions. Your Lordship and your
Lordship, please tell in which market Sahara.com is dominant and in which market it abuses its dominant position, leveraging its position.
Thank you for your question, Your Lordship. Your Lordship, for the purposes of establishing abuse in the first issue, we have delineated 3 relevant markets. This is because the theories of abuse applicable to each of these 3 relevant markets in which Sahara.com operates is different. These 3 relevant markets are, firstly, the e-commerce services marketplace, secondly, the OTT streaming services marketplace, and thirdly, the subscription-based delivery services marketplace. It is also a contention that Sahara.com is dominant in 2 of these 3 identified relevant marketplaces. These relevant markets being the e-commerce services marketplace and the OTT services marketplace. We established this dominance by placing reliance on Section 19, subsection 4 of the Competition Act, which lays down or lists certain criteria which must be relied upon in order to assess the dominance of an enterprise in a relevant market. Now, Your Lordship, this section, before we move on to this section,
Section 19, the explanation appended to Section 19 in particular, defines dominance as the position of strength which allows a competitive entity in order to operate without the constraints, without competitive constraints, and to affect its customers as well as its competitors in a manner which is in its favor. And it is in this regard that the factors listed under subsection 4 of Section 19 must be looked into. The council would humbly request your lordship and your ladyship to refer to subsection 4 of Section 19, which lists certain factors, including factors such as the economic power of enterprise, including commercial advantages over competitors. This is clause D of subsection 4. Your lordship, it is humbly submitted in this regard that Sahara.com, in its operation within the e-commerce marketplace, had access to economic power by virtue of its association with its parent enterprise. If your lordships would refer to paragraph number 4 of the Moot proposition, it states that, my apologies, your lordship, if you refer to paragraph number 7 of the Moot proposition, it states that Sahara.com is an e-commerce platform owned by Sahara.com Inc. USA. Sahara.com Inc. USA is an American multinational technology company focusing on e-commerce, cloud computing, online advertisements, and it is a $200 billion company and considered to be one of the largest American technology companies. What this shows is that the economic prowess of Sahara.com's parent company accords certain advantages to its subsidiary, which is the Indian subsidiary, in our present case, Sahara.com. By virtue of this economic prowess, Sahara.com is able to dominate its relevant market in the e-commerce marketplace. The reason.
Also, I want to intervene.
Yes, sir.
You are telling that Sahara.com gets its strength because of its parent company in America.
Yes, your lordship.
So, but we have to see its position of dominance in the Indian markets, which is the relevant markets.
Indeed, your lordship.
So, how you can prove that Sahara.com is dominant in Indian markets?
Indeed, your lordship. It is in that regard the submission of the council that the mere association of Sahara.com with its parent company affords certain commercial advantages to the firm. Not only in terms of the economic powers that this association is likely to have, something that is inevitable in the present case, but also by virtue of something which is known as network effects, your lordship. Your lordship and your ladyship, network effects are the tendency of consumers to go towards or to move in the direction of enterprises that already have an established consumer base. This is because such entities tend to instill trust within the consumers. And this network effect is something which is a characteristic feature of digital markets. And since Sahara.com does operate in the e-commerce services marketplace, which is distinct from the traditional marketplaces, this is something that has been upheld by landmark cases of the CCI, such as Iboga versus Flipkart. The fact that online retail services marketplaces are inherently distinct from offline services marketplaces by virtue of the distinct natures of services that they provide, also the distinct categories of consumers that they cater. In the present case, the Moot proposition also mentions that Middleton has a primarily young population and that youth, primarily the Gen Z, as has been mentioned in the proposition, prefers to avail the services of online market services as opposed to the traditional conventional brick and mortar services. In this regard, the network effects, which are likely to be generated by virtue of Sahara.com's association with its parent enterprise, Sahara Inc. USA, these network effects are likely to accord it a commercial advantage over its competitors within the Indian market, because such competitors are not likely to have access to such economic prowess, because the likelihood of them also having such a backing in terms of an international parent company is very low. Additionally, this parent company is also one of the largest technology companies, which means that Sahara.com also has a commercial advantage in terms of the technology that it offers to its consumers. This is something that has also been mentioned in the Moot proposition. And with regard to the dominance of Sahara.com in the e-commerce services marketplace, it is essential to note that Paragraph number 12 of the proposition mentions that the filtration of content on exclusive plus homepage as per the preference of customers quickly became popular among the middle-tone youth. In this context, it is important to note that the Moot proposition refers to the ability of Sahara.com to make use of the data that it acquires from its customers through its operation in the e-commerce marketplace and use this data to provide tailor-made content to the customers in the other relevant market of OTT streaming services. It therefore does leverage your lordship and your leadership, its position in one relevant market in which it is dominant in order to consolidate its position in another relevant market. In this regard, it is important to note one of the landmark decisions of the CCI in the case of Sonam Sharma versus Apple Inc., wherein the CCI laid down a four-pronged test in order to determine whether the views of leveraging has been made out against an entity or not. This four-pronged test posits that firstly, the relevant markets of the product being tied and the tied product must be different. In this present case, we've already established that the relevant markets of the OTT streaming services and that of e-commerce streaming services are different. Therefore, the first prong of the test is satisfied. Secondly, the entity which has been abused or allocated to abuse its position must also exercise or occupy a position of dominance in the said market. And in the present case, we've established to you that by virtue of commercial advantages that it has over its customers and the consequently reduced countervailing buying power of the consumers. Because panel note that this commercial advantage also restricts the ability of its competitors to access the consumer base, which prefers custom-made content. Now, since competitors in the market do not have access to consumer data, the kind of data which Sahara.com has access to, by virtue of its dominance in the e-commerce marketplace, the competitors cannot compete with Sahara.com on an equal footing. And therefore, the consumers themselves do not have an alternative, a meaningful alternative, to switch to these other competitors that are available in the market. And therefore, the countervailing buying power of consumers, another factor that has been mentioned under subsection 4, section 19 of the Act, is significantly reduced, and therefore the dominant position of Sahara.com is established in both of these markets. But in addition to that, the third prong of this test, which mentions that the consumers must be coerced in some form or way for such conduct to fulfill the criteria of leveraging. In this context, it is submitted that consumers were in fact coerced into buying the services that Sahara.com offered in the e-commerce retail services as well. This is because Sahara.com integrated these platforms by way of a technological tie. The services were provided on one consolidated platform, and the customers could only be allowed to use the services of the e-commerce platform if they had also subscribed to Sahara Exclusive, which is a service which is offered by Sahara.com in the relevant market of subscription-based delivery services. Through its Sahara Exclusive venture, Sahara.com offers delivery services to its customers within 1 day and charges certain costs for such delivery. It offers these subscriptions in form of 3 packages. These are quarterly subscriptions, semi-annual, yearly subscriptions, and monthly subscriptions. Now, your lordship, a consumer could only avail the services of the OTT streaming service that were offered by Sahara.com if they also had a subscription of these delivery services. Now, in the present case, not only are these services entirely unrelated, but also the fact that there was a technological tie-in which required consumers to purchase a subscription which had no relation to the contract that they actually wanted to enter into, which was the subscription of the OTT streaming market. They were coerced into also using the services of Sahara.com in the e-commerce marketplace. And therefore, coercion for the purposes of this test is established. The fourth prong of this test is the absence of objective justification. Now, the CCI, through its decisional practice as well as through the explicit recognition of a defense in the form of the explanation which is amended to Section 4 of the Competition Act, Section 4(2) more specifically of the Competition Act. It recognizes the absence of abuse in case such discriminatory condition or price which may be adopted to meet the competition. Now, while this defense is explicitly recognized by the legislative scheme of the Act, it is our contention that no such objective justification is made out by Sahara.com in the present case. This is because the requirement to meet competition requires for there to be a necessity, something that which is beyond the control of the enterprise in question, which requires it to undertake the conduct which has been alleged to have abused, which has been alleged to have resulted in negative effects for the consumers. Now, in the present case, integrating the services of an e-commerce marketplace and an OTT services marketplace does not there is no objective justification for doing it. While Sahara.com may contend that efficiencies were created on account of such integration, or that the competition was significantly increasing, which required the creation of or integration of such services in order to sustain its position in the market. The point remains, Your Lordship and Your Ladyship, that there was no objective necessity which required Sahara.com to undertake such a practice to maintain its position. Which is to say that even if Sahara.com had not integrated the services of these two relevant markets, it would still have been able to sustain itself in the market, simply because it is dominant in the market and an increase in competition does not really affect its position in the market. And therefore, there exists no objective justification for leveraging its power in the relevant market of e-commerce marketplace to enter the other relevant market of the OTT streaming services market. With respect to the second submission within the first issue, which is whether Sahara.com indulged in tying of services, it is important to note that the relevant market, which is alleged to have been dominant in the present case, is not the e-commerce marketplace, but the OTT services market. Please note, Your Lordship and Your Ladyship, that this marketplace, which is dominant, is the e-commerce marketplace for the purposes of my second submission, because of the four-pronged test, again, which establishes time in any case. This four-pronged test requires that dominance must be established in the market which a competitor uses in order to enter another market. Now, in the present case, it is our contention that Sahara.com has used its dominance in the OTT streaming services market in order to consolidate its already dominant position in the e-commerce marketplace. The manner in which this has been done has already been explained by the council to you in the previous submission, which was by integrating platforms in requiring consumers to buy a subscription-based delivery contract, which would inevitably result in consumers also availing the services of the e-commerce platform, which is Sahara. And therefore, the four conditions in the case of time are also fulfilled. The first one being the existence of two separate relevant markets. The second one being dominance in the said relevant markets. The third one being the element of coercion. And the fourth one being the absence of an objective justification defending that conduct. With respect, if Your Lordship and Your Ladyship is satisfied with the submission of the council with respect to the first issue, she'd like to move on to the second issue in the present case. Much obliged, Your Lordship and Ladyship. With respect to the second issue, it is our contention that the CM has erred in dismissing the allegation which was leveled against Sahara.com, that it has abused its position in the international cricket World Cup streaming services in order to leverage its position, but also by abusing its dominant position in order to impose unfair and discriminatory prices and conditions on its consumers. For the purposes of this issue, Your Lordship and Your Ladyship, we have identified the relevant market to be the international cricket streaming services market. Now, the reason why this market constitutes a market separate from the OTT streaming services market is because it fulfills certain criteria that have been laid down under subsection 7, section 19 of the Act. Now, subsection 7, section 19 of the Act lists certain factors that must be considered while determining or while delineating the relevant market, the relevant product market in particular. This section mentions characteristics like consumer preferences and existence of specialized producers. In the present case, it is our humble submission that the existence of specialized producers in the present case requires that the market for international cricket streaming services be separated from the larger market of the OTT streaming content streaming services. This is because all OTT platforms do not have the access to telecast rights that in the present case Sahara.com had access to, which means that only competitors have access to telecast rights to speak World Cup cricket streaming services. They provide such services, which is why we must constitute a separate market altogether. Because panel, the delineation of relevant, my apologies, tribunal, the delineation of relevant market is based on the idea of interchangeability and substitutability. And interchangeability in the present case cannot exist when OTT platforms or the OTT retail services market does not have, or competitors operating within this market do not have access to provide consumers with that service. Consumers cannot avail the services of competitors operating within the larger OTT market base in case they do not provide that service. And it is also our contention that clause C of subsection 7, which is consumer preferences, is also something that is very important in the factual matrix of the present case. This is because consumers regard international cricket streaming services to be distinct from the general OTT entertainment content. This is something that was also established in the landmark case of. Allow me a moment here also make a picture. This was established in the landmark case of Surendra Singh Barmani versus BCCI, wherein the CCI held that cricket streaming services, in fact, even the different formats of cricket, including international cricket World Cup or domestic cricket World Cup, constitute different markets. This is because consumers attach different relevance and different. The consumers attach different degrees of importance to these different formats of cricket streaming, and therefore they constitute different services altogether. And this is something that is squarely the ratio. While the ratio may not be squarely applicable in the present case, this observation of the CCI is squarely applicable in the present case because consumers regard some services to be distinct, and therefore the two markets constitute different markets. With respect to the dominance that Sahara.com exercised in this market of international cricket streaming services, it is important to note that Sahara.com was the only entity which was afforded the telecast rights of such World Cup when the council seeks a humble extension in 2 minutes, Your Lordship. Much obliged, Your Lordship. It is important to note that Sahara was the only entity operating within the OTT streaming services, which was accorded the telecast rights of the international cricket World Cup streaming. This is and it got hold of those rights by way of a bidding process. What this does essentially to the market is it creates a market structure which is inherently in favor of Sahara.com in its operation within the international cricket streaming services. This is something that again has been mentioned under subsection 4 of section 19 of the Competition Act, which lays down factors that must be considered when considering whether an entity is dominant within the relevant market. Secondly, Sahara.com within this relevant market also had access to advantages that perhaps competitors operating within the DTH platforms or cable operators wouldn't have had access to. With respect to online live cricket streaming services, the services offered by this market is also distinct from those offered by cable operators or DTH operators because of the mobility that it affords to these services. Consumers prefer this mobility and are unlikely to consider the services offered by DTH or cable operators to be substitutable, simply because the youth cannot stream the services from the convenience of their home or their workplace in case of a DTH service provider, which is why Sahara.com was one of the only enterprises engaged in the provision of such delivery. In addition to that, the availability of data with Sahara.com allowed Sahara.com to, yes, Your Honor, I'll take just a minute to wind up my arguments. In the present case,
Just Andy, Madam, I have some questions.
much of it.
Council, your application was dismissed under 26(2), right?
Yes, sir.
You started your argument saying that it's mandatory on the commission to have proceeded on an inquiry. But don't you think you failed on your prima facie case? But that's the first thing you had to show. The investigation is not automatic.
Yes, sir.
So you didn't address that issue at all. That should have been your first issue.
Yes, sir.
It was a failure on your part of being unable to show your prima facie case. As you started, you said that the commission did not get into the evidences, but given whatever you have produced had to be taken as gospel truth, it should have disclosed a prima facie case because there was non-disclosure. So none of the issues address that.
Indeed, your leadership, in that regard, my submission is that we never contended that the CCM failed to consider the evidence that was substantiated. It is our contention that a prima facie case has in fact been made out, and the case has been made out on the basis of the submissions that were just mentioned. In the present case as well, we have not really used any evidence in the form of market share numbers or the evidence of foreclosure. But we have made submissions that on the level of a prima facie or at the level of a preliminary investigation deserved to be heard, and something that the CCI should have referred to the DG under 26(3) of the Competition Act, something that the CCM fails to do in the present case. That is precisely our contention. If that satisfies the query of your leadership, the council would like to conclude with the submissions. Much obliged to Lordship and your leadership. It was an honor arguing before this honorable tribunal, and with that, I give the floor to my co-counsel, counsel number 2, and I am very thankful.
I request Speaker 2 on behalf of the appellant to approach the dais.
Please proceed.
The option is to be ready if you are satisfied with the submissions of my. Am I audible? Your Lordship and leadership, if you are satisfied with the submissions of my co-counsel with respect to issue 1 and 2, the council would like to proceed with issue 3 and 4. Much obliged, Your Lordship. Your Lordship and your leadership. The third issue is that whether CCM has heard in discussing the allegations that Sahara.com has leveraged its has indulged in predatory conduct by allowing viewership to live International Cricket World Cup for free to the mobile users. Your Lordship and your leadership, with the delineation of the relevant market, that is online live International Cricket World Cup streaming services, and the establishment of dominance of Sahara.com by my co-counsel. For the sake of brevity, the council respectfully seeks permission to pivot the focus on the third sub-issue at hand, which relates to the predatory pricing. Much obliged, Your Lordship and your leadership. Your Lordship and your leadership, it is contended on behalf of the appealants that the Sahara.com has abused its dominant position in the relevant market, and that the Competition Commission of Middleton has heard in discussing the allegations that Sahara.com has indulged in predatory conduct by allowing viewership to live International Cricket World Cup services for free to the mobile users. Your Lordship and your leadership may refer to Section 4, Explanation B of the Competition Act. Your Lordship and your leadership, the Section 4 Explanation B states that predatory pricing means the sale of goods or provision of services at the price which consists below the cost as may be determined by regulations of production of goods or provision of services with a view to reduce competition or eliminate the competition. Your Lordship and your Ladyship, here with a view being the important part of the definition. Your Lordship and your Ladyship, the definition shows that there has to be an intent, or there has to be an intention to eliminate the competition and to establish the predatory conduct. If your Lordships and your Ladyship may please refer to the para 21 and 22 of the proposition. Your Lordship, there can be no your Lordship, para 21 and 22 talks about that the respondent introduced a subscription fee of ₹100, and it also imposed a condition that the consumer can only buy annual subscription of Sahara Exclusive. The appealants would like to request the Honorable Tribunal to take note of the fact that the respondents has also scrapped off the subscriptions, the quarterly and half-yearly subscriptions. Your Lordship and your Ladyship, there can be no objective justification to the fact that the respondent stopped offering the free of cost services in middle of the World Cup season with effect from 1st November 2023. In simple terms, your Lordship and your Ladyship, if a consumer wishes to watch the World Cup match for 19 days, he will have to pay for the annual subscription of Sahara Exclusive, which is the delivery platform, and additionally ₹100 per month more for the subscription of Exclusive Plus, which amounts to the exploitation of customers. Your Lordship, the European Commission states that it is not mandatory to prove that the competitors have existed from the relevant market. Even the plausibility that the dominant entity tries to prevent the competitors from competing in the relevant market shall also be taken into the consideration. Your Lordship and your Ladyship, the respondent has a concurrent viewership of 50 million viewers. Here, the Council would like to bring the attention of the Honorable Tribunal to para 16 of the proposition. Your Lordship and your Ladyship, it states that there exists a viewership cap of 30 million viewers throughout the 8 market players in the OTT market. Your Lordship and your Ladyship, this acts as a cogent reason to establish that the Sahara.com attracted all the consumers by engaging in predatory conduct and prevented the competitors from competing in the relevant market, further establishing that the respondent has engaged itself in anti-competitive purposes. Your Lordship, the Council further submits that the Sahara.com has the exclusive telecast rights of the online live streaming of the Cricket World Cup. The respondent, by engaging themselves in the predatory conduct, significantly affected and exploited the consumers, since the consumer had no other option and were forced to buy the subscription of Sahara Exclusive and Sahara Exclusive Plus in order to avail the services. If your Lordships and your Ladyship may refer to para 23 of the proposition. Para 20 states that there was a major uproar amongst the consumers as the change of subscription fee wasn't anticipated, and due to unfair conditions, some customers did not renew the subscription, and others were forced due to the presence of monopoly which was stated by the respondent in the relevant market of online live streaming cricket World Cup services.
Just clarify, when an entity is in the markets and the products or services provided, its demand in the market increases and it raises price. Initially, however, the price was negligible or zero. So why you consider it as a predatory pricing? It's not the rights of an entity to charge something based on the market demand. I think in a competitive market, it should happen like this. Is correct, right?
Indeed, Your Lordship. Your Lordship, to to show that there was a predatory, to prove or to establish that there was a predatory pricing, it must be done with the intention to eliminate the competition. So intention, here the intention needs to be clear. Your Lordship, if Your Lordship may, if Your Lordship, please allow, if please allow. Your Lordship, in addition, the services which was provided by the, and as you mentioned that initially everyone gives the services free of cost, and after that they start charging some price. Your Lordship, and your leadership, there's also exists there also exists phenomena of penetrative pricing. Your Lordship, we need to understand that when we talk about penetrative pricing, it is with respect to short-term. So when an entity gives offers or provides free of cost services for a short term, it is considered to be as penetrative pricing. But in this case, the respondent has provided the services for a very long term. The Exclusive Plus was launched in the year 2020, and till 2023, it was providing the services for free of cost. And now it has now suddenly it has started charging the subscription cost of Exclusive Plus, which is 100 rupees. And apart from that, they have also scrapped off the quarterly and half yearly subscriptions. And they apart from that, the services were also stopped in the middle of the World Cup tournament. Your Lordship, this shows that there was an intent that to eliminate the competition, because as if Your Lordship and your leadership can refer to the para 21, it shows that the World Cup was started on 5th of October and concluded on 19th November. Your Lordship and leadership, in the middle of the World Cup session, the respondent notified on 15th October that they will be charging the subscription fee of with effect from 1st November 2023. This shows that at first the respondent has gained a concurrent viewership of 50 million viewers, and after that when they captured the market, they started charging the subscription fee from them, which shows that there was a predatory conduct on the part of respondent. If Your Lordship is satisfied with this, Your Lordship, in the case of transparent energy and tech group, key conditions were laid down to determine the predatory pricing. The conditions are that first, the price must be lower than the cost. Second, that such predatory pricing must be done with the intention to eliminate competition. And third, that with a motive to recover the loss incurred by jacking the prices high again after eliminating the competition out of the market. Your Lordship and your leadership, in the present case, all the conditions of the predatory conduct has been satisfied by the respondent. Moving further, Your Lordship and your leadership, in the case of MCX versus NSE, no cost benchmark was determined because zero pricing is a situation in which unfair pricing is proved without eliminating any cost benchmark, because there exists no price which was charged from the consumers. Your Lordship and your leadership, in the present case as well, zero pricing was practiced since the services were provided free of cost to the mobile users, establishing the situation of unfair pricing. Therefore, it can be established that the respondent was indulged in predatory pricing. If Your Lordship and your leadership are satisfied with the submissions with respect to issue 3, the council would like to move towards the submission with respect to issue. Much obliged, Your Lordship and leadership. Your Lordship and your leadership, the issue 4 is about that whether CCM has erred in dismissing the allegations that the conduct of Sahara.com has resulted in denial and foreclosure of market for other OTT players in contravention of Section 4, subsection 2, clause C of the Act. Your Lordship and your Ladyship, it is contended on behalf of the applicant that the Competition Commission of Britain has erred in dismissing the allegations that the conduct of Sahara.com has resulted in denial and foreclosure of market for other OTT players and in contravention of Section 4, subsection 2, clause C of the Act. Your Lordship and your Ladyship, the denial of market access has not been defined anywhere in the Competition Act, but it can be understood as when a dominant enterprise engages in a conduct by which it forecloses the market or it restricts entry of new players in the market, then it would be considered as a denial of market access and it would fall under it would fall foul of the provisions of the Competition Act. Your Lordship and your Ladyship, to establish whether Sahara.com's conduct resulted in abuse, we need to refer to the entry barriers which exist in a market. Your Lordship, there exist your Lordship and your Ladyship, there exist two types of market barriers in the relevant market. First being the structural barriers, and second being the strategic barriers. With respect to the structural barriers, your Lordship, the first barrier would be the cost advantage. Entry barrier usually is measured by the amount of money that the market player takes to enter an industry, and your Ladyship. So your Lordship and your Ladyship, in the present case, the telecast rights were bought for rupees 25 billion MNR. Moreover, since services were provided free of cost, Sahara.com had an advantage of having big pocket by being the subsidiary of the Sahara.com Incorporation, USA, which is the parent company of the Sahara.com. Therefore, it was in a position to provide the services of free of cost. Had there been some other enterprise, they wouldn't be able to provide service free of cost because they have incurred a substantial amount in facilitating that services, which is 25 billion MNR. Your Lordship and your Ladyship, now the Council would like to proceed with the second type of structure, the second structural barrier, which is that first mover advantage with respect to providing tailor-made services and personalized services. Your Lordship and your Ladyship, the respondent has a first mover advantage. And it is considered as a strategic factor because by entering the market first, the enterprise already establishes themselves. In the given case, the respondent was the first service provider who provided the personalized, tailor-made services based on using the data of the consumers, which is why it has which is why in the relevant market of providing personalized services, the respondent has a first mover advantage because no other market player, though no other OTT player in the market has access to the consumer data. Your Lordship, with respect to the third strategic barrier, which is economies of scale. Your Lordship and your Ladyship, in the present case, the respondent, by virtue of being established player in the market monopoly, your Lordship, in the present case, the respondent, by virtue of being established player in the market, attained monopoly. Now, additionally, the tailor-made homepage by way of usage, the usage of data led to the majority subscription, and it also established. It also led to an established customer base for the respondent, thus creating brand loyalty and preventing new entrants from entering the market. Moreover, the respondent also resulted in limit pricing by facilitating the services at a loss. Now, your Lordship and your Ladyship, the Council will be establishing that there were no strategic barriers in the limit market. With respect to the first strategic barrier, which is predatory pricing. Your Lordship and your Ladyship, since the Council has already dealt and established this barrier at length, the Council seeks permission to move forward with the next strategic barrier. Your Lordship, the second barrier would be the test of commercial sense and date intent. Your Lordship, no commercial sense test, Your Lordship, a commercial sense test is a test of intent and the modus operandi of the respondent in consonance with the intention to eliminate the competition. Now, Your Lordship, the council would like to move towards the next contention of the appealant, which is that the plea of objective justification must be rejected. Much obliged. Your Lordship and your Ladyship, a dominant undertaking is entitled to take reasonable measures to protect its consumer interests. But the justification provided by the respondent, by the dominant entity, which is respondent, was that. Apologies, Your Lordship, in but the justification provided by the dominant undertaking can only be considered when the factors are beyond the control of the dominant company, which necessitates the conduct. If Your Lordship and Your Ladyship, even Your Lordship and Your Ladyship, even if the reliance is placed on placed to the para 19 of the proposition, it states that the rise in the number of players as well as users has led the companies to adopt innovative strategies. Your Lordship and Your Ladyship, such conduct by the enterprise was not necessary at all, and in order to protect was not necessary at all in order to protect their commercial interests. And the Sahara.com has already submitted by the by my co-counsel that Sahara.com holds a dominant position in the relevant market, which is why there exists no necessity for such conduct. Therefore, the plea of objective justification must be rejected. And in the case of East India Petroleum Private Limited versus South Asia LPG Company Private Limited, the CCM observed that the denial of market access in any manner by a dominant enterprise cannot be justified. Your Lordship, now the council would like to. Yes, Your Lordship, with respect to the foreclosure of market, the foreclosure of market refers to the ability of firms to prevent the entry of other firms in the market. Your Lordship and Your Ladyship, Sahara's strategic manual of tying its services of exclusive to exclusive plus live streaming of World Cup, then subsequently increasing the subscription fee and restricting the customer to commit to an annual contract. It has thus not only strengthened its position in the market, but has also introduced barriers that hinder new entrants and potentially drive existing competitors out of the market and resulted in foreclosure of market for other OTT players and in contravention of Section 4, Subsection 2, Clause C of the Competition Act. Now, with Your Lordship and Your Ladyship's due permission, the council would like to move towards the period of the appeals. Yeah.
From your submission, I think the petition is not bona fide. Your petition is not bona fide. The reason being that all the facts on which you base your allegations were known to you since long. It's only when that new subscription fee came up, that's when you came before the commission. But you lay stress that Sahara had access to all the data, that it had a delivery service. It's all known to you. So I think it's not bona fide. You have to first establish that. It's not bona fide, and anyways, people have stopped its subscription. They have some of them have not renewed it. So it's not worked on the benefit of Sahara anyways also. So I think it's not bona fide. It's absolutely not bona fide because all of you were there. And what Sahara was doing all this time was known to you. So you just come out for nothing. And anyways, it was all known to you. The Sahara was the only entity which had, won that bid. So you knew that the live streaming will only happen through Sahara. All these facts were known to you. So this all the time, the delay does not make you a bona fide applicant.
Indeed, not your leadership. Your leadership, if as please allow me a moment. Your leadership, could you please repeat the last part of the question?
Try to understand what I'm trying. Your entire case, you have been asserting on certain facts and conducts of Sahara, which were known to all of you since long. You are a private association doing the same kind of business, been known to you since long. All this time, you did nothing about it. You also knew of this fact. It was a public news that Sahara is the only one who's got the bid, and the telecast will happen through Sahara. All this were known to you. Further, the Moot proposition says that people did not renew. And they walked out of this entire scenario. So therefore, if you base your case on the past facts, then you're too late to this commission. And this delay does not make you bona fide. Especially because you are all experts in the same platform. It's not like somebody else is walking into and filing an application before the commission. And if the lone fact that you have to keep that, they charge a subscription fee, but then the Moot proposition shows it's gone against Sahara. So the commission, the appellate tribunal feels that it was not bona fide, and therefore there was no prima facie case. I ask you the same question because it was not an automatic thing. Commission at the first stage is not getting into your evidence, it's nothing. You failed to show your bona fide and prima facie.
Indeed not leadership. Because when we talk about the comparative bidding, that the respondent much of it to so if talking about the bidding, your leadership, the bidding, everyone was aware of the fact that only Sahara Exclusive Plus is going to have the telecast rights with respect to the cricket. With respect to the telecast rights of the World Cup cricket match. But here, no, with respect to the Moot. So, first of all, I would like to bring this fact to the attention. Bring this fact first of all, I would like to bring this back to the notice of the tribunal that MOTA, the Middleton OTT Association, works for the benefit of the OTT players in the relevant market. Now, your lordship and your leadership, when we talk about when the Sahara was providing the services free of cost, at that time, no OTT players had any objection with respect to that, because at that time there was no predatory conduct, or there was no anti-competitive practices which was followed by the Sahara. But when it started charging for that services, and when the prices shot up in order to gain gain back the revenue which was incurred in facilitating the services, and which was incurred in obtaining the telecast rights. At that time, the Sahara was indulged in the predatory conduct, and which also resulted in the denial and foreclosure of market. Apart from that, your lordship and your leadership, the proposition states that some people did not renew, but it also states that there was a your lordship and your leadership, it also states. Allow me a moment, your lordship. So there was a major uproar amongst the consumers. Leadership may refer to the para 20, that there was major uproar amongst the consumer after the tweet went viral, as this change of the subscription fee was neither intimated nor anticipated. So everyone was aware of the fact that the Sahara is providing free of cost services, and even the media the media had appreciated this generous move of Sahara when they were providing services free of cost. But after that, in middle of the cricket tournament, they started charging for the services, which also shows the malignant intent on part of the respondent to gain to lure the customers first by indulging themselves in the predatory themselves in predatory pricing, and ultimately apart from my last submission would be that so if I may move towards the view. Therefore, in the light of the facts of the case, issues raised, arguments advanced, and authorities cited, the appellant most humbly submits before the Middleton Competition Law Appellate Tribunal that it may be pleased to adjudge and declare that first, the appeal before the Middleton Competition Law Appellate Tribunal is maintainable. Second, that the CM has heard in discussing the allegations against Sahara.com. Third, to set aside the order of to set aside the decision of CCM. And fourth, that the respondents are liable to compensate the Middleton OTT Association for losses caused by their actions and omissions, and or pass any such order, direction, or relief as it may deem fit in order to uphold the principles of justice, equity, and good conscience. And for this act of kindness, the appellant shall be duty bound forever free. Thank you.
With the due permission of the honorable judges, I request Speaker 1, on behalf of the respondent, to kindly approach the dais and start with the pleadings. Speaker 1 is requested to approach the dais.
Votes for names is the council property. Greetings to the honorable bench. Council seeks permission to collectively refer the bench as your honor. The council here is representing respondents in the case of Middletown OTT Association versus the Competition Commission of Britain and Sahara. We are here to respond to the appeal that has been filed under Section 53 by the defendants. If the honorable court is well versed with the facts of the case, council seeks permission to proceed directly to the issues of in the present context, there are 4 issues that have been established before this tribunal, and that will be dealt by the respondents. Council that is seen. I will be dealing with first 2 issues and taking a time period of 20 minutes, and the rest 2 issues will be dealt by my co-counsel. Council seeks permission of the court to proceed with the submissions. The first issue that we are dealing with today is whether CCM has made any error in dismissing the allegations that whether there is an abuse of dominance by Sahara.com. Secondly, whether there is a time arrangement that Sahara is involved into. And thirdly, whether they have leveraged their position in the e-commerce market to enter the one-day delivery subscription and OTT service. Council humbly submits that CCM has made no error to pass the order, that there is no prima facie case before the CCM that there is an abuse of dominance, as CCM has properly investigated the factors as per the section 19(4) and section 4 of the Competition Act 2002. Further, the council will be establishing the issue with a 3-fold argument. Firstly, we'll be establishing that there is presence of a relevant non-dominance of Sahara.com in the relevant market. Secondly, Sahara.com has not leveraged its position in the e-commerce market to enter upon the OTT services as well as the one-day delivery subscription. And thirdly, there is no existence of time arrangement as per section 3 subsection. Submitting upon the dominance, it is very much required as per the Competition Act Section 4 states that firstly to prove dominance, you have to satisfy the proof that whether there is a presence of relevant market in the state of relevant market as per section 2R of the Competition Act states that relevant market includes relevant product market as well as relevant geographical market. Relevant product market that has been established under section 2D has to be established that there is a product, a market which has to be stabilized and has substitutable and interchangeable in nature. In the present context, to establish what is the relevant market, three factors has to be considered. The factors are firstly the demand substitutability, secondly the presence of SNP tests, and thirdly that the end use and the characteristics of it. Here, the market of the state of credit, as per the facts today, is a growing market for technology. OTT services as well as the e-commerce market has seen a boom since the year 2010. And as per the facts, in the year 2016, Sahara.com has come into existence by launching Sahara.com, a platform which is relevant in the e-commerce section. Further, along with the e-commerce, they introduced Sahara exclusive subscriptions that give one-day delivery options to the subscribers of Sahara exclusive, and they come along with three types of subscriptions that include quarterly, semi-annually, and annual subscription with desired price ranges that they offer. Now the question that Sahara.com has been elicited, they have used the e-commerce platform, whether they are
Still, please clarify whether Sahara is in e-commerce or Sahara is a platform providing platform services to the sellers as well as the client. What is the role of Sahara and whether we can make a distinction between
To answering that question, Sahara.com is being owned by Sahara Incorporation, which is an American multinational. Sahara.com is in the position of having their market as in the two sectors of market. Firstly, e-commerce market that includes the sales of various products, and secondly, after the launch of Sahara Exclusive Plus, in the OTT service market that includes the streaming platforms. So thereby the relevant product market that has to be established. It's got two sets of market. Firstly, a relevant e-commerce market, the state of credit, and secondly, relevant OTT services market that is in the present context substantiated by the demand substitutability. Demand substitutability that is demand substitutability means when a product can be changed or replaced by another product. Now, to take in the present context, OTT service as well as e-commerce services are substitutable with the traditional ways of e-commerce, that is they have to visit to shops and buy and purchase items. Whereas OTT services are a substitute to the traditional broadcasting services. Thereby, Sahara has taken the reliance to that and introduced the platform of e-commerce services as well as OTT services in the year 2020 respectively. Secondly, in the SNP test that has been taken into consideration. SNP test talks about significantly non-transitory increase in the price. It satisfies that when there is a significant increase in a price, and if a customer has another option where they can switch into, then customer prefer that for better quality and increase in price, they can switch. The OTT services and the e-commerce services comes in handy in this, where we can approach and take directly buy any products or items just by sitting at home and order and get all the services. As well as OTT service, we can watch any of the entertainment shows, being anywhere in. Thereby, the SNP test has been satisfied by the involvement of Sahara.com in these two relevant. Thirdly, the third factor that is to be considered by determining the relevant product is similar physical characteristics and end use of products. OTT service as well as e-commerce service is the enhanced form of traditional markets. Thereby, it comes with the same user capability and characteristics, just with the enhancement of having the relevant and efficient methods of buying and taking the things. Thereby, the relevant product market is the e-commerce market as well as the OTT service. Talking about the relevant geographical market, that reveals that there is a significant role in the market. Both are two different separate markets, and we have to consider in the case that two separate markets exist, and Sahara has been the proper consideration considering both of the markets in the growing trade, the geographical. The two separate markets, there's an existence of two separate markets, but we have to also consider that these two markets have been not tied in, but they have been done by Sahara to provide the efficient service to both the platforms that they are on. Because as per the fact, with consideration to subscription to single platform, they are getting the benefit of two services, where they can also avail the e-commerce service. With that, they will be getting one delivery services. Along with that, in the same platform, they can avail the entertainment or the OTT service. Moving further, the geographical market in the present context is a state of development where all the e-commerce are established. Now, when the relevant market has been established, we have to prove that there is non-dominance in such a region. To establish that whether there is non-dominance, three factors have been considered as per section 19, subsection 4, which is 13 factors from subsection A to M about whether the enterprise is dominant in the market. To consider that, first factor that is humbly relied by the evidence, that is the market share of the enterprise. The facts, no case states about the exact figures of market share of Sahara. They have relied that a company has been owned by Sahara Incorporation, which is an American multinational company and has a worth of 200 billion. But just having such a worth doesn't create a sense that they have a huge impact on the market because there's a presence of healthy competitors in the market. Facts shows at para number 12 of the proposition that Your Honor, para number 10, last 3 lines, that there was a lead to OTT players, popular OTT platforms like Netflix, Amazon.com, Amazon Prime Video, and Disney Plus Hotstar. So before Sahara.com, Amazon Prime Video, which is one of the major players, is also in the platform e-commerce. Thereby, they are on both the establishment, that is e-commerce, as well as the OTT platform service. Thereby, it establishes that there was a significant competitors in the market. Thereby, market share alone cannot be the sole predatory thing to establish that there has been an abuse of dominance, as established by various significant decisions that include Vikrant Pagi case that has been decided by CCI, the president. The next factor that is to consider is the size, importance, and commercial advantage of the company. Although Sahara.com has a net worth in comparison to its parent company of 200 billion, but that has to be considered as a whole because Sahara Incorporation has been involved in various businesses that includes e-commerce, digital cloud computing, digital streaming, and various other relevant. Because that established the $200 billion figures that it is not alone that it has a market share of $200 billion in the e-commerce section or in single terms in the OTT section. Thereby, there are significant competitors in the market. Thirdly, it is not restricting any of the competitors to grow in the market. There is a healthy competition. Anyone who want to enter the market follow the same pattern. They can come to the market and follow the same as followed by the Sahara. If we talk about the entry barrier that is considered, there is no entry barrier. Only barrier that is the regulatory barrier. To come into existence, enterprise has to follow certain regulations as established by the statutory provision. And that is the only barrier that exists in the present market. Thereby, the convention of entry barrier has to be written. Thirdly, it does not impose any unfair pricing of conditions. The only condition that came up after the launch of Sahara Exclusive Plus and on the onset of the International Cricket World Cup is that we have scrapped off the semi-annual and quarterly plans of Sahara Exclusive, and they have imposed a minimum charges of rupees MNR 100 on the subscriptions of 1 month basis for the Exclusive Plus subscription that provides the telecasting rights. There was a contention that this is an excessive price imposed upon the customers, and as it has been during the onset of cricket, ICC Cricket World Cup, this has led to the abuse of data. Negating about that, the facts also reveal that there was an estimate. Firstly, to correct that, we have established that Sahara has a viewership of 50 million people, but they have not a viewership, but it was an estimate that was supposed to be taken that 50 million viewers may be coming on the final match day show of telecast, thereby to provide more effective service, because to take a payload of 50 million subscribers on a platform, there has to be stable network and stable enterprising protocol that has to be followed. So there is no proper any gladness during the telecast events. And to provide such a service, Sahara.com proposed a price of 100 rupees subscription. The fact also has to be taken into consideration that for a period of almost 3 years, my clients were giving a free of cost facility for availing Sahara Exclusive Plus. And that itself device that Sahara was growing with the market and helping the consumers to get a better facility or the better enhancement of services. On their own losses, they have covered and given the best of the services that they can provide, and thereby contesting that they were giving a long-term free subscription, and now they should continue with free subscription. Led to the huge losses by my clients, and that is against Sahara.com, because to fight with a healthy competition in the market, it is very much required that we have to take certain considerations into account. And imposition of price is not an abuse of dominance, because if that imposition of price or any of the things on the services or products that we are offering is for the growth and for the sustenance of the competition, then it doesn't lead to the abuse of dominance. Second, thirdly, we have not indulged in any of the practices that led to the denial of competitors or led to restriction of consumers to our brand. We only give a complimentary service that is Sahara Exclusive Plus is available to all the subscribers who are involved in Sahara Exclusive. We are not binding them that they must go to the platform and watch at only Sahara Exclusive Plus. There are presence of 7 other OTT platforms as well as predetermined in Netflix, Amazon, and Disney Plus Hotstar, which are one of the most foremost players and biggest players in the OTT market. The consumers has very much quantity available in the competition. Thereby, we are not restricting anyone in the market to grow and to facilitate their working as an enterprise. Thereby, Section 4.2a, which determines that there is a restriction or limit on the enterprise to grow, that has not been neglected. Now, to talk about further that whether there is a tie-in arrangement as per Section 3.4a, when we have done a thing that we have given OTT service along with the e-commerce service, when they depend on 2 different markets, it has to be submitted that in relation to a tie-in of services, we have to consider is of FX Enterprise Solutions Private Limited versus Hyundai Motors India Limited, cited at page 11 of the compendium. Whether in that case, CCI came up with what tie-in arrangement means and what are the factors have to consider when you have to take that there's an abuse of tie-in. The 3 factors protocol will be. Firstly, there has to be a presence of 2 separate products. We humbly admit that there are 2 separate products. But the most important factor that has to be considered that the seller must have led to affect a non-insubstantial amount of commerce. Now, in the present case, the facts remains that there is a 20% year-on-year growth in middle term, and it is expected that by 2030 the market of OTT service e-commerce will reach at a price of 30,000 crores. Thereby, all the competitors in the market have the opportunity to grab that growth and grow their enterprise. Sahara.com doesn't impose any of the restrictions on competitors to go with them. Thereby, it has not leveraged its positions in the e-commerce market and giving a healthy competition to compete with the pricing strategies and sustain the competition. They have taken such a consideration. and thereby come up with this position that there is no time of arrangement, we conduct issue 1, and furtherly they have not abused their dominance, and for the sustenance of the competition, they have such a marketing strategy that has been. If your honors are satisfied with issue 1, council's information proceed with issue. The issue 2 that we are dealing with is deals with issue 2 deals with whether CCM has made any error on dismissing the allegation that Sahara.com has leveraged its position of having the telecast rights. Whether when they have the telecast rights of international cricket World Cup 2023 and abuses dominance of having this telecast right to curb or restrict the customers to annual subscription and impose a fee of ₹100 that has been divided upon the exclusive plus system. Whether it was an abuse and whether such thing has contravened section 4(2)(e) of the Competition Act that talks about when enterprise which is dominant in one relevant market takes such dominance to enter another relevant market, different category of products, but of homogeneity. Council that victim has been no evidence. They have considered the proper factors that has been stated in section 19(3), section 19(4), and section 4 of the competition. Summate upon that, council will be dealing with threefold issues. Firstly, council will be dealing about the leverage of position of the retail class. Secondly, we will be dealing with whether there is an abuse of dominance on having such telecards. And thirdly, we will be dealing with the contravention of section 4(2)(e). Firstly, talking about the leverage of position in telecast. The telecast rights that are being granted is granted was procedures as per establishing the Sport Broadcasting Rules of Act of 2007. Now, Sport Broadcasting Act of 2007 has specified section 3 that talks about if there is in some sport of having a national importance, then Prasar Bharati or the DD National has the right to telecast that thing for free. That establishes a position that Sahara.com is not an exclusive player to telecast international cricket World Cup, but it is also available for free for the customers who don't have option to buy such a subscription. Thereby, for the imposition that Sahara.com has leveraged such a position that they have a telecast right, and now they are imposing such a charges to dominate or abuse their dominance is very well negative because customers have the option and having a secondary option is very well satisfied. There's no abuse of dominance or leverage of this position. Now, talking about the strategy that they have taken upon, the Competition Act talks about penetrative pricing strategy. And one of the landmark judgment that talks about is of the Bharti Airtel Limited versus Reliance Communications and Jio, which elaborately talked about the penetrative pricing strategy. And the case was involving the facts that Jio, when it was launched, was offered for a free service of internet for all the consumers in the market. And this period of free services continued for almost a period of 3.5 years. Thereby, indeed, I will conclude that. The penetrative pricing strategy that has been involved in the present case, whether Sahara.com was offered for a period of 3 years. Competition Commission of India, in that relevant case that we are referring to, established that penetrative pricing strategy can be followed by an enterprise, even the enterprise is dominant in the market, but there should be no predatory intent that has to be involved. My co-concept will be very elaborately dealing with predatory intent and the non-presence. Here, the main focus is on penetrative pricing strategy that is. And my clients have followed the same strategy to fight with the competition that is existing, thereby combining the two separate categories of product to for the benefit of consumers will foster a healthy competition in the market.
So you paid a hefty amount for getting that telecast right, and why you initially give it to free? You're supposed to recover your cost. Why not you consider predatory pricing Why not if you consider your intent is to wipe out competition in the market? I basic question. Okay. Six, 1 minute to next quick answer. Sure. So talking about that, the predatory pricing is not coming to existence because we are the Sahara exclusive trust plan was launched in the year 2020, and the cricket rights, the cricket telecasting rights that we are talking about, came in the year 2003, and for the first time in the year, Reddit Town was hosting such competition of such a high level as a fax reveals, and thereby voting upon that why we were giving the free services at the initial stages, but giving imposing a charge of rupees, minimum charge of rupees 100. Then answer could be to get a more efficient, more stable service during the period when this cricket, which was the aim of very much national politics, came into existence, and our consumers doesn't suffer, as it is very well said that if you have a responsibility towards the consumers, you have to abide by it, and such responsibility has to be shown, and thereby Sahara.com has never neglected this position and shown a good content, good intent towards the consumer, and taken such a consideration that everyone have a healthy competition and they do not go.
Yeah. I think we agree this was international cricket, right? It was a bidding. So obviously your ability to technically telecast must have already been assessed. So what happened in the midway that you thought your services were not good enough? So that again does not show that you're bona fide. One. Second, you were initially able to give that delivery, that free delivery, because your mother company or your holding company had enough of finance to do that. So that it was meant to capture the market, and as you said that in cricket, as your proposition is that cricket is supposed to be a big thing in this state. So you ultimately knew that one day if you can have this bidding for which you already have the financial ability, you would easily recover your costs. So therefore, yes, from day one, all your strategies were meant to be not bona fide, and the midway increasing of this cost was pre-thought of, because otherwise you would not have got the bid at all if you were not capable of delivering, because I mean every cricket again has to be delivered to that level of, and your performance has to be there. So I think it's all a sham. You did it with an intention.
I appreciate question that is one. But answering to that regard, Disney Plus Hotstar that was already in the existence in the market. As we already know that Disney Plus Hotstar is one of the major players in the streaming of live cricket shows or any other sports business. Now talking about the bidding process in that regard, bidding process is open for all the enterprises in the market. If we talk about the bidding process, it is not easy because our client has paid a relevant price in that.
No, that's not the point. The point is, because you had a technical capacity already assessed, you paid a hefty price and you got it. You had no reason to make it initially free. You did it only, so that you capture more viewership, which otherwise were available for other purposes, and then increase the cost. Yes, so that's the thing here. Obviously, you have won it. That means you're technically superior than all of them. And financially, you obviously ensured the cricket body more revenue. When you're ensuring that revenue and you give it for free, it is obvious.
Answering to that regarding your option, a free services or offering a service or having a position of acquiring services. Secondly, if you are having services, there was also
Council, you are seeing facts in isolation. Let's take it together. That's why you're not addressing.
taking together that there was an estimate of 50 million viewers on the platform. To accommodate such a hefty amount of viewership, there has to be certain stable component that has to be taken into significance. and thereby imposing certain
I
charges.
think in middle,
Indeed, it
in
also
the
because,
middle.
at the starting, there was not a relevance, or Sahara.com was not in.
Council, we don't agree on that. I don't, please, I think that, I mean, international cricket, body has more better things.
Indeed, is taking that into consideration, but I will stick to the answer that has to substantiate with the efficiency and the competitors in the market. Sahara.com has taken all the things in the package.
Council, your time, sir.
It was honor to argue.
I request Speaker to, on behalf of the respondent, to kindly approach the dais and start.
Greetings to the honorable bench. I'm Speaker 2 from the Council of the Respondents and certainly will be dealing with issues 3 and 4 that relate with the issue of non-engagement of Sahara.com in predatory conduct, and certainly there is non-denial and non-foreclosure of the relevant market. With your honor's permission, the council seeks permission to proceed with the third issue of the case. Much obliged. So the third issue in the present case deals that the Competition Commission of Middleton has not erred in dismissing the allegations that Sahara.com was indulged in predatory conduct by allowing viewership for free to the mobile users of the International Cricket World Cup. The council would be proving the same basing on a fourfold argument. Firstly, that there is lack of dominance by Sahara.com in the relevant market. Secondly, that there is non-presence of the abuse of dominance by the enterprise. Thirdly, there is non-engagement in the predatory conduct. And fourthly, that there is presence of the legitimate business justifications. Your honors, to begin with the first head of the argument. There is lack of dominance. The Competition Act of 2002 certainly provides that in order to ascertain dominance, there must be an enterprise who has exercised the same in the relevant market. In order to ascertain the association as an enterprise or the company as an enterprise, it perfectly qualifies the definition of an enterprise provided under Section 2 Clause H of the Competition Act. Moving ahead of it being in the relevant market, we find that there is non-presence of the relevant market in the present instance. As your honors, if you would refer to the case of M.M. Mittal versus Mrs. Parival Developers, provided by the Council for the Respondents at para 86, page 22 of the memorial. The case certainly stated that ascertainment of the relevant market is very essential in order to analyze that there is abuse of dominance. In the present instance, your honors, the streaming of the International Cricket World Cup was not restricted only to the OTT platform of Sahara Exclusive Plus. Instead, the other OTT platforms also have the right to gain the bidding and also to stream the same in their OTT platforms. Further, your honors, in the case of ICC Development International versus New Delhi Television Limited, provided at para 87, page 23 of the memorial, your honors, it certainly states that the score of a match is in public domain and can be broadcasted by any channel as part of its right of report current news and the events. Thereby,
Council live telecast is given to one platform only, I think.
Your honor, the facts are completely silent that Sahara Exclusive Plus was the only company that had gained the bidding. There might have been other companies also, as it has never stated in the facts that it has gained the exclusive rights of live streaming. Also, your honors, certainly coming to this case, we find that cricket, which is a match of national importance, and there where the sports and its score and the matches, which could be lively streamed through other broadcasting units as well, as also provided by the Sports Act, that if a private enterprise has live streaming rights of the sports broadcasting, it is abided and bound to share the same with the public domain, that is Prasar Bharati. And in this relevant case, it is nowhere provided that Sahara Exclusive had not provided those broadcasting rights to the other dominant public players in the market. And thereby, it will not be said that there is presence of the relevant market and Sahara Exclusive Plus is dominating its position. Certainly, Your Honours, there is also lack of dominance in the relevant case. Firstly, because as para 16 of the Moot proposition suggests that along with Exclusive Plus, there were 7 other OTT players in the market having a viewership cap simultaneously of 30 million. So alone taking the viewership cap of 30 million being associated with Sahara Exclusive Plus is not justified, as there were also 7 other major OTT players which simultaneously had that viewership cap. Secondly, Your Honours, as paragraph 10 of the Moot proposition suggests that Sahara Exclusive Plus is not one of the early movers in the market. There were other relevant OTT players like Netflix, Amazon Prime, and Disney Plus Hotstar who were present in the market from the very beginning before Sahara Exclusive Plus gained dominance and came into the market. Thirdly, Your Honours, as para 18 of the Moot proposition suggests that the Middleton OTT Organized Association is an official voice of the OTT players. But taking into consideration the fact that Mota was only comprising of more than 60% of the OTT players in the Middleton market, it had not considered the voice of the other, set aside 40% of the OTT players, which were including the 8 major OTT players in the market, including Sahara Exclusive Plus. Thereby, Mota coming up with the point that it is the official voice of the OTT players and putting this application in benefit of the OTT players in the market cannot be relied upon. Moving ahead with the point, Your Honours, so the second head deals that there is non-presence of the abuse of dominance by Sahara Exclusive Plus in the relevant market. Your Honours, the non-presence of abuse of dominance is a res ipsa loquitur. By the first 2 issues also, it speaks for itself that there was no enterprise, and certainly it has also been provided under section 4 clause subsection 1 of the Competition Act that no enterprise or group shall abuse its dominant position, because dominance in itself is not actionable, but the abuse of dominance in the market is. And certainly in the present case, Sahara Exclusive Plus has not indulged in the abuse of dominance in the relevant market. As in the case of UPSC Securities Limited, which is provided at page number 23 of the memorial submitted by the respondents, it had said that dominance is not prohibited by the Act, but only its abuse is. Considering to that, Your Honours, explanation A of section 4 of the Competition Act provides the meaning of dominant position in the market, which considers 2 tests. Firstly, that there is independent operation of the enterprise despite of the other competitive forces, and secondly, that it adversely affects the competitors and consumers in the relevant market. Conceding to that fact, Your Honours, the first point that it has adversely, that it was capable of independent operations, the same could not be relied upon, as along with Sahara Exclusive Plus, there were other OTT players in the market. Those were providing the video streaming, that is the relevant product market in the current instance, was providing video streaming of services. But here, considering that OTT Exclusive Plus was not having that instant market share, as the facts are completely silent about the amount of market share that Exclusive Plus was having, so it could not be adversely inferred from the facts that basing upon the viewership gap or the viewership base that it had, it was having a great market share also in the Middleton state, as it was only comprising of the 40% of the OTT players, and which was also inclusive of the other 7 players in the market. Thereby, it will not be inferred that it was having a very large market share in Middleton. Secondly, Your Honours, there's also no adverse effect on the competitors and the consumers, as it is well said that the cricket sport is a sport of national importance, and it is not restricted to be streamed by only any private enterprise or any single OTT platform. Here, in the instant case, where it is not evident that Sahara Exclusive Plus had the exclusive rights of live streaming of the Cricket World Cup, thereby also that the Prasar Bharati had the right of live streaming of the Cricket World Cup as it was a public domain and as per the Sports Act, it has the rights. Thereby, there is no infringement of the rights of the consumers. The consumers were free if they were not abiding by the subscription cost or they were not able to pay the same. They were free to move to other OTT platforms or to the other public domain that was streaming or showing the news and the scores of the live cricket match. Moving ahead, your orders, the third subground states that there is non-engagement of exclusive class in predatory conduct. Predatory conduct, the meaning, which was also considered by Raghavan Committee in 2000, said that where a firm with a market par price below the cost to drive competitors out of the market and to acquire a dominant position. Certainly, explanation B of section 4 also provides the meaning of predatory pricing, that which has two conditions. Firstly, that the prices must be below cost, and secondly, that there must be an intention to reduce competition in the market. But in the instant case, your orders, exclusive plus had no intention of reducing competition in the market. It was not engaging in any of the anti-competitive conduct that was being carried on by the OTT players. As providing of the free services, as it was providing free services earlier, but later a subscription cost that was imposed was only for providing better services to the consumers, your honors. As if your honors could refer to para 22 of the Moot proposition, it perfectly states that it had included the subscription costs for telecasting of live matches to provide a better sound, clarity, ad-free, and stadium-like feel at home. So all these technological advancements were being carried out by Sahara Exclusive Plus. In consideration of that, it had imposed the subscription cost of 100 rupees per month. Further, your honors, if it is considered that the subscription cost was a hefty amount, in consideration of that, if a consumer has to pay rupees 850 for an annual subscription, and the other two subscriptions that were scraped away, which are the quarterly subscription and the semi-annual subscription, amounting to 300 MNR for 500 MNR for 3 months, and your honors, if your honors could refer to para number 8 honors, it was rupees 100 for 3 months, and 500 for 6 months. If we calculate the annual amount that it would cost if a consumer is going to take the annual subscription, it would only cost 850. But other two subscriptions, if the consumer wanted to continue it for a year, would certainly move above the price of 850. And if the consumer was only willing to be in connection with Sahara Exclusive Plus for the live streaming of the International Cricket World Cup, then only an additional amount of rupees 100 is to be paid, which amounts to 950, which is certainly less than the MNR 1000 and MNR 1200 that has to be paid for the quarterly and semi-annually subscriptions. Also, your honors, it is considered that as the cost of the product is determined, it has to be measured in the average variable cost, as was held in the case of Mrs. Transport Energy versus TCP-RO systems provided at page 23 of the compendium, your honors. It held in that case that determining predatory pricing, the average variable cost has to be taken into consideration and not the normal pricing strategies. And in absence of any of those facts, that what are the pricing strategies and the pricing amounts that the other OTT players are carrying on with or having, it cannot be ascertained that what is the average variable cost in the current market. And in absence of the same, it could not be held that providing a subscription fee of 100 MNR or the annual subscriptions was amounting to a more price or was under the average variable cost that was being leveraged by other OTT players in the market. Also, your honors, Sahara Exclusive Plus did not have the exclusive right. In absence of this exclusive right, it is seen that the consumers are free to move to other OTT platforms. In no way it is binding the consumers only to itself. There are several OTT platforms in Middleton State. Also, the live cricket telecast that is being happening is also in a public domain through Prasar Bharati. thereby the consumers are not being, the rights of the consumers are not being anyways hampered, as they are not bound to be stuck by the services being provided by exclusive class. Also, in consideration to that, Your Honors, the facts provide that there were several consumers who were not able to pay their subscription costs and had certainly moved away of the subscription and had not continued it with it further. This shows that the consumers were in no way restricted to the offers or the amounts or the services being provided by the OTT platform Sahara Exclusive Plus, which renders that the market was free and having a healthy competition. And Sahara Exclusive Plus was in no way involved in anti-competitive conduct in the relevant market. Further, Your Honors, the last segment of this argument states that there was presence of legitimate business justifications. Legitimate business justifications, if I could read for the convenience of the bench, provided at para 104, page 27 of the Moot Memorial, that legitimate business justification means any purpose furthering in the best interest of the company and shall include the following, where the fifth point suggests that any other reasonable purposes. And from para 23 of the Moot proposition, we find that there were technological advancements being done by Sahara Exclusive Plus after providing of the live streaming of the International Cricket World Cup. Therefore, in order to sustain with the services that it was initially providing to the consumers and continue providing with the same services in future as well, it was bound to leverage the cost of 100 MNR per month. And also, the technological advancements and the innovations that were taking place was essential to ascertain that the consumers are getting the same best quality services. And also, the consumers were in no way bound to stick to the same services that Sahara Exclusive Plus was providing. Thereby, this does not mean that Sahara Exclusive Plus was in any way engaging in predatory conduct by the enterprise. And hence, considering to the services that it was providing and to the best interest of the consumers that were attached to this OTT platform, Sahara Exclusive Plus, none of the conducts represent that it was involved in predatory conduct. Your Honors, with Your Honors' permission, the Council seeks permission to proceed with the fourth issue of the case. Much obliged, Your Honor. So the fourth issue in the relevant case deals that the Competition Commission of Middleton has not erred in dismissing the allegations that the conduct of Sahara.com has resulted in denial and foreclosure of the market of other OTT platforms. Neither is it is in contravention of Section 4, subsection 2, clause C of the Competition Act. The Council will be proving the same based on a threefold argument. Firstly, that there is non-denial and non-foreclosure of the relevant market. Secondly, there is creation of a hub and spoke market. And thirdly, that the existence of more than one dominant enterprise in the relevant market is not barred by the competition. Moving with the first leg of the argument, Your Honors, Section 4, subsection 2, clause C of the Competition Act provides what is denial and foreclosure of the relevant market, where any practice or practices being resulting in the denial of the market access in any manner causes to the abuse of dominance by the enterprise in the relevant market. Your Honors, in order to ascertain the abuse of abuse of dominance by the enterprise, there are 13 factors from clauses A to N provided under Section 19, subsection 4 of the Competition Act, which are to be considered, which also includes market share, the size of the enterprise and the consumer base, the dependence on the consumers on the enterprise. In this relevant case, the facts do not suggest what is the market share of the enterprise at the current point of time. Also, the consumers are not completely dependent upon the Sahara Exclusive Plus for getting their services. So this does render that there was non-denial and non-foreclosure of the relevant market. Secondly, Your Honors, there is non-engagement in predatory pricing. Your Honors, as it was proved in the previous issue, I would also like to bring into consideration before the bench that in the case of MCX Stock Exchange and others versus the National Stock Exchange, provided at page 30, para 119 of the Moot Memorial. In that case, CCI had observed that providing zero pricing by the National Stock Exchange in its currency derivative segment was a sound business strategy, and was not eliminating the competition, and it could not be said to be a pricing was unfair or predatory and was not violative of Section 3 and 4 of the Competition Act. In consideration to that fact, Your Honours, since the relevant market depends on the basis of the state-to-state basis, and also we find that OTT platform in Middleton was growing on a year-to-year basis with 20% growth and is estimated to reach to 30,000 crores by 2030. The imposition of free services when Sahara Exclusive Plus came into the market is in no way anti-competitive or is in no way barring the healthy competition that is still prevalent in the market. Abiding by this case, Your Honours, it could be seen that there is non-engagement in predatory pricing by Sahara Exclusive Plus. Further, Your Honours, CCM is justified in dismissing the complaint that was filed under Section 26, subsection 2. As it was argued initially by my learned counsel for the appellants that they have filed a complaint under Section 26, subsection 1. But to make a correction, the complaint was filed under Section 26, subsection 2. Your Honours, in that case, Section 26, subsection 2 provides that if there is no prima facie case found against the enterprise, then CCI has the authority of dismissing and passing order in that regard. In regards to that, Your Honours, if we refer to the case of Rohit Arora versus Zomato, we find that there was no predatory conduct, and CCI had found that Zomato was not indulging in any of the activities that was resulting in denial of foreclosure of the market by the for the competitors, and it was the order which was passed under Section 26, subsection 2 was completely valid. Also, to bring to the notice of the Honorable Bench, my learned counsel for the appellants pray to dismiss the order that has been passed by the Competition Commission for Middleton. In order to ensure that prayer that is granted in their behalf, they have the responsibility of making the Competition Commission of Middleton a party in the present case. Your Honours, if you could refer kindly to the front page of the memorial submitted by the learned counsel for the appellants, they have only made Sahara.com as the respondent party in the present case. Whereas in the case of CCI, Your Honours, I request only for a minute to conclude with my submissions. Much obliged. In the case of CCI versus State Authority of India, it was clearly held that CCI is to be considered to be a necessary or a proper party when the case has been brought before the appellate tribunal. And in the present case, if they are not making CCI as a necessary or as a party in the present case, then for surely the prayer that they have appealed before the tribunal would not be granted for the same. Also, Your Honours, the formation of Moot, which only constitutes of 60% of the OTT players in the market, leads to formation of a cartel where they are indulging, as per para 18 of the Moot proposition, they interact with the ministries, policy regulators, and other such bodies in the relevant Middleton. They are not showing that it is the free voice of the OTT players. Instead, this agreement is in contravention to the cumulative voice of the OTT players in the market, and hence they are acting as an appreciable adverse effect that is being constituted by them in the relevant market, as they are not considering the voice of all the OTT players as a whole, and they are neglecting the 8 major players in the market as a whole. Your Honours.
Already addressed that. Please conclude.
Your Honour, the council seeks permission to proceed with the prayer of the case.
Just said that there is a difference between 26(1) and 26(2).
Your Honour, under 26(1), 26(2), it provides that if a prima facie case
No,
is
the application has, you said the application has been filed under 26(2). That's not the case.
Your Honours, before
The
the
order has been passed because it is, so that's the, that's the.
My
Yes,
apologies for
yes,
that.
so therefore that would be a wrong proposition.
Permission is always filed under Section 19.
Your Honour, my apologies for the same. I was about to say that.
26(1) and 26(2) would be the 2 ways in which the commission would look at the matter, but those are, yeah, that's the 2 alternatives in which we can proceed, but.
Your Honour. Your Honor, my apologies for stating the wrong.
Yeah, so that's,
the order.
yeah, that would not be case against them.
Yeah.
You decided, let's assume, accept your proposition that yes, it does not say that Sahara got exclusive. The fact remains that it's only you in the Moot proposition have made it free. So, and your subscription at least at that time was ₹100. So when you are for ₹100, I can enjoy this exclusive plus for 3 months. Right? And in midway, you ask them to pay another ₹100. So obviously, intentions are clear. You can't walk out of that fact that you ensure that even if the other players in the market are providing the same live stream, but definitely they were with cost. The newspaper said it's only you who is without cost. So you ensure that their customers change the loyalty, and in midway you made the profit you wanted to. And obviously, if somebody has already paid 100 or has already paid 80, you would not walk out and say, okay, fine, I just give 100 more. So you just utilize that 100 more.
Your Honor, in the instant case, if we answer to that question, that we have not leveraged our position in the relevant market as providing of the 100 MNR that was.
Say that you went free.
Your Honor, certainly.
You went free after so much of investment. You went free. Others didn't.
Your Honors, it is certainly that only exclusive plus was free, but only after taking the subscription of Sahara exclusive, which was not free. So we were leveraging the costs to the consumers, but in order to ascertain that they would
100 plus 100. You made that.
Your
You made that 100 at the cost of others.
Your Honors, in consideration of that 100 MNR was only imposed on the consumers in order to provide them technologically sound and innovative services that also we as exclusive plus were not expected.
As your co-counsel could not answer, you suddenly thought that you were not up to the mark.
Your Honor,
Yes.
not up to the mark, but we were not expecting a viewership base
The
that would serve to
International Cricket Council will not like this.
Your Honor,
Thank you.
Your Honor, with your kind request, I would like to proceed with the prayer of the case. Much obliged, Your Honor.
Be brief.
Wait, is that?
Why would you urge this prayer? I know the act in all Moot, but why would you urge a prayer? They have a prayer. You have a order in your favor.
Your Honor, in order to uphold that order, we are praying before the appellate tribunal. Therefore, in the light of issues raised, arguments advanced and authorities cited, we certainly pray and implore before the Honorable Tribunal to uphold the order that was passed by the Competition Commission of Malaysia. Also to declare that Sahara has not indulged in the abuse of their dominant position as per Section 4, and also not indulged in the tying of services, and also not leveraged their position in the relevant market, and also to pass any other order as the tribunal may deem fit in their conscience, in equity, justice, and good conscience. The council rests the case.
Thank you so much.
Much obliged, Your Honor.
With your permission from the honorable judges, we can further proceed with the rebuttal as well as surrender. I request speaker on behalf of the appellant to kindly approach the dais and initiate with the rebuttal.
Why don't you be brief?
Your Lordship, with respect to the arguments with regard to the dismissal of allegation under Section 26, subclause 2, subsection 2 of the Competition Act, it is submitted that the dismissal was unfair and the grounds of dismissal have already been made out in submissions on behalf of the appellants. But in addition to that, the bona fide intention of the appellants is also laid out. And in this regard, reliance must be placed on paragraph number 16 and paragraph number 18 of the Moot proposition, which states that the Middleton ODT Association was formed after 2023 when the increase in the number of players within the ODT market was noticed. This means that even though Sahara.com did abuse its dominant position, the Middleton ODT Association was only formed after a period of 8 years of the establishment of Sahara.com, and which is when the cause of action also arose. And moreover, the cause of action also arose after a change in the prices and change in consumer behavior was noticed following the practices that were adopted by Sahara.com in the international streaming services market. Secondly, with respect to their reliance upon the defense of objective justification, it has already been established by counsels on behalf of the appellants that such objective justification can only be made out in case of a necessity. And in this present case, since Sahara.com was dominant in the market, no such necessity existed on its part to impose such conditions or to conduct itself in a manner which harmed the interests of competitors. And therefore, the defense of objective justification is not maintained. But in addition to that as well, they mentioned market shares in order to rebut the establishment of dominance that as has been made out by the case of the appellants. This is something that is highly contested and something that the decisional practice of the CCI also objects to. This is because in landmark cases of periodic charges, just an extension of one. Much obligatory, teacher. There was an honored argument before this honorable tribunal. Thank you.
The due permission of the honorable judges, I request speaker on behalf of the respondent to kindly approach the dais and start with the surrogate round.
Your Honours, my learned counsels for the appellants have pointed out three major things. Firstly, that MOTA was formed after 8 years of the inclusion of Sahara Exclusive Plus in the market. Referring to the Moot proposition, Your Honours, it could never be, it is not evident that in which year MOTA was perfectly established. Instead, they are manipulating the facts in their favor and not relying by the maxim of allegans contraria non-est addendus, which means that a person alleging contradictory facts should not be heard. Because Sahara exclusive, Sahara.com was introduced in the market in 2016, and further Sahara exclusive was introduced. Sahara exclusive plus was introduced in the market. The OTT platform was introduced in 2020, which marks a gap of a difference of 8 years. But it was not MOTA that was established in the year 2020, which is certainly a non-reliance of the facts and the manipulation of the facts done by the counsel for the appellants. Further, Your Honours, the objective justification that has been questioned by them, it is certainly right that the viewership base of the Sahara Exclusive Plus arose to 50 million subscribers, and also in order to ascertain that they were providing the same technologically and innovatively sound services, which were ad-free, which were giving stadium-like experience to the consumers, they had this justification of leveraging a subscription cost of 100 dinar. Whereas in the state of Militant, it is also not true that there were other OTT players providing the same services free of cost, which instead they were only charging MNR 100, which in turn does not amount to a cost which was below the average variable cost. Also, Your Honours, in lack of any facts ascertaining the market share of the enterprise, the dominant position of the enterprise could not be established in the relevant case, and certainly it could not be said that enterprise.
Counsel, why are we replying to the issue? When was this body formed? Does the formation of the body in 2012, 11, 20 make you better or worse? So it's not a relevant fact. So counsel should know that it's not a relevant fact. Don't waste your time on that. It doesn't decide your fate this way or that way.
Certainly, Your Honours, only
Thank you.
to the consideration of the honourable.
Yes, you should know as a counsel, you should know even as a lawyer also, you should know it's the fact, if an issue is raised and it's not relevant, don't answer it.
Your Honours.
Otherwise you give meaning too much to the opponents and then your own case goes out.
Certainly, Your Honours. Much obliged to argue before the honourable bench.
The session of the court is over. I request the judges ushers to kindly escort the respective judges to the green room.
And esteemed guests, participants, and students.
We trust this afternoon finds you in good health and high spirits. It is with great pleasure that we address you today.
I, Arnav Singhal, along with Prakruti Mitra, will be your hosts for the day. It gives us immense pleasure to welcome you all to the valedictory ceremony of the National Moot Court Competition 2024, conducted by Xavier Law School in collaboration with the Competition Commission of India.
Proceeding with the event, let us immerse ourselves in the timeless elegance Proceeding with the event, let us immerse ourselves in the timeless elegance and profound artistry of Bharatanatyam. Bharatanatyam is one of the oldest and most widely practiced classical dance forms in India, known for its intricate footwork, expressive gestures, elaborate facial expressions, and graceful body movements. Please join us in welcoming Ms. Oitri Hira from the School of Commerce at Sam University, Bhubaneswar, as she takes on a journey through the enchanting world of this reverb dance form.
नन्दिनि नन्दितमेदिनि विश्वविनोदिनि नन्दते विजम् रक्ता तत्किततकसि रक्ता तत्कितजम् नैगिरि नन्दिनि नन्दितमेदिनि जम् रक्तति तत्किततकसि नैगिरि नन्दिनि जम् नैगिरि नन्दिनि नन्दितमेदिनि विश्वविनोदिनि नन्दते वरविद्धशिरोदिनि वासिनि विष्णुते भगवति देशितिकण्ठकुटुम्बिनि भूरि कृते जय जय Shudhavirodhi, Shirodhi Krita, Mother, Shudhaviri.
Thank you, Ms. Vaishnavi, for giving the event.
It gives us great pleasure to invite our esteemed guests for today's event to join us on the stage. Sir, please. Moving forward, we would like to invite the chief guest of the day, Father S. Anthony Raj, S.J., Registrar of Exam University, Bhubaneswar, to please accept the memento as a gesture to thank him for the presence. We would like to invite Dr. Avnish Bhatt, faculty convener of the Moot Court Committee, to present the memento to Father Registrar.
With our heartfelt gratitude, we invite the guest of honor, Dr. Vidyadhar Maji. Dr. Vidyadhar Maji is an advisor in economics and head of the Mergers and Acquisition Division at the Competition Commission of India. Sir was also the director and joint director at the Competition Commission of India. Sir is also a faculty member of the Indian Institute of Foreign Trade, Institute of Chartered Accountants of India, and Government Autonomous College, Phulbani, Odisha, in the area of economics, and also served in the National Sample Survey Office, Government of India. We are indeed obliged to have your expertise and vast knowledge to enrich us. We request Dr. Maji to please accept the memento as a token of respect. We also request Dr. Avnish Bhatt, faculty convener of the Moot Court Committee, to present the memento and sapling to the honorable guest. So, please. Moving forward, it is with profound honor that we invite Dr. Avnish Bhatt, the dedicated faculty convener of the Moot Court Committee. We request Sir to join us on the stage and address the audience. Sir, please.
Thank you very much to Ms. Prakriti Mitra and Mr. Arnav Signal. 3 days extravaganza. Festival for the law students, which is coming to an end for this session. But for the upcoming session, of course, such kind of festivals we are going to showcase in front of everyone. There is a juxtaposition of the intellectual thought processes and flood of emotions since not last 3 days, but since last 3 months, which we were having. Inside fight, outside fight, sir, ऐसे करना है, वैसे करना है, we have to do like this, we have to do like that. 2 a.m. call, sir, हुआ नहीं. I said, okay, will be done. Sir, teams have complained like this. I said, okay, will be done. Don't worry. So many emotions while I am standing here. So I would like to first of all acknowledge our honorable chief guest, our own Reverend Father S. Anthony Raj, Senior Jesuit, the Registrar of the Exam University, 24/7 available for us. Anytime, Father, this is a problem. Go ahead. And only one thing, approved. Whatever you ask, approved. He used to just write approved, means all work done. So Father, thank you very much for gracing this occasion, coming down, giving up busy schedule. So you are in a law department, Father, I think. Since last 3 days, you are constantly with us. Now, secondly, I would like to acknowledge our honorable guest of honor of the day, our Dr. Vidyadhar Manji. Sir, thank you very much for your assistance to Exam University in the intellectual thought processes, for coming down to our university. And again, I would like to special mention the Competition Commission of India, who acknowledges the effort of the Xavier Law School, XIM University, being in collaboration with us. And we have tried our level best to put forth the transparent event. We have tried to showcase that XIM University also have a strength to conduct this and international and world level event also. We have tried our level best. Without the go ahead and without the support of one man, we couldn't stand here and conducting this event. Our own Reverend Father Vice Chancellor, who has permitted us to conduct this event. And whatever we have requested to Honorable Father Vice Chancellor, in a single go he accepted and he said, go ahead, please conduct this event. So I would like to special mention in absentia Reverend Father Vice Chancellor for his constant support to the law school throughout the year and maybe again in the coming years also. So in absentia for Father Vice Chancellor, please a huge round of applause. A constant support. Again, it's a 24/7 support. Our respected Dean Sir, Dean of Xavier Law School, Dr. Narayan Chand Sarangi. Unfortunately, he unable to join in last 2 days due to some medical emergency in his family. But he is constantly in touch with me, with Father, and he extended all his support in absentia, whatever he could do. We understand the situation. If there is a medical emergency of the family members, what is the mindset during that time? But still, he is constantly supporting us. Even before we enters into this place, he is asked all the proceedings, what you are going to do, in what manner. So again, in absentia, to our respected dean sir, thank you very much. All our faculty members who have constantly supported us in various ways, and the people who constantly working, I would like to name one by one our own administrative officer, Mr. Prashant Kumar Mahapatra. Constant, immense support we are extending. At times, emergency situation, honorable justice is about to come, sitting judge of High Court. And we were in some serious struggle due to the protocol issues and many other things, but he has handled all the things very beautifully. He extended all his support to us. So thank you very much. Mr. Bigan Raj, all the auditorium you are seeing, the management, every time he will be ready. Okay, you want to go for rehearsal? I'm okay, giving you the time. Go ahead, check the arrangements. Mr. Vijay Kumar Rao, for all the arrangements. Our purchase officer, for all the purchasing done, even the last moment purchasing. Fine, go ahead. IT staff, what you are saying, the display boards, the other displays, everything. Our MTS staff, who is not in a picture, working behind the stage for us day and night. Thank you very much to all of you. And many people who are working behind the stage. But I would like to say our strength is our organizing committee. The organizing committee of this National Moot Court competition. Without this, This event society company. At the same time, I remember last year I am also standing here when we conducted a moot court event in collaboration with National Human Rights Commission. Our former chairperson, Shivangi Das, is also here. Similar sort of involvement during that time. So again, organizing committee, you are the strength of this event. So again, a very big round of applause for all of you. The speech may end, but the impact which we have tried to showcase, maybe you may be impacted because of that. And similar kind of events we are going to conduct in the near future also. And the lastly, if I conclude my arguments without acknowledging our sponsors, you can see a lot of logos there. So they have extended an immense support. Our sponsors, specifically, if I name it, then Vishwam Jewelers. Thank you very much. All the sponsors you can see. Surya Garden, Good, Fortune, so many sponsors who have supported us in many ways. So I am highly indebted to all of them, and also Competition Commission of India, who also had extended the financial support in the conduct of this said event. So again, I would like to thank you very much to all these sponsors. With this, I would like to have my wife here. Now, we would be anticipating and would like to hear from the honorable guest of honor and chief guest. So thank you very much to all of you.
Thank you, sir, for your motivating words.
Proceeding further, we would like to invite Ms. Vanita Jana, convener of the Moot Court Committee, to come on the stage and present the report about the event.
A very good afternoon to our esteemed chief guest, Father Registrar, our guest of honor, Dr. Vidyadhar Maji sir, respected Dean sir in absentia, esteemed guests, all the participants, esteemed members, the members of the organizing committee, and one and all present over here. I am Ranita Jana, the student convener of the Moot Court Committee 23-24, and as an avid mooter and a winner of national myself, it gives me a sense of personal emotions and a distinguished honor to have convened this grand 3 days event and the related privilege to present the report of the National Moot Court Competition of Xavier Law School, Extime University, Bhubaneswar in collaboration of the Competition Commission of India today. The National Moot Court Competition of Xavier Law School focuses on the significance of competition law in the evolving legal landscape. It provides participants with a platform to explore the nuances of corporate law and competition law, enabling them to tackle real-world issues and enhance their analytical and advocacy skills. Emphasizing the importance of fair competition, the event aims to ensure access to a wide range of goods and services at competitive prices, fostering innovation, specialization, and consumer welfare. We have a diverse participation from across all over India, precisely 14 different states, and have among us reputed universities, including 9 NLUs, including state universities, including Institute of National Importance, and reputed private universities among us. This diverse participation with a promising gender parity highlights the widespread interest and engagement in the competition, showcasing a broad representation of legal talent from across various regions, academic backgrounds, and socio-cultural things. move on with the competition structure and the adjudication mechanism involved. The competition commenced with the researcher test on 16th February 2024, followed by the draw of lots and memorial exchange. In the preliminary round, 8 deserving teams advanced to the quarterfinal rounds based on merit, and to ensure fairness and transparency, we have customized a software for the implementation of the evaluation mechanism. In the subsequent rounds that was conducted later, we had the blessings on the opening ceremony from Honorable Mr. Justice Dr. Shivo Shankar Mishra sir, and our guest of honor, Honorable Dr. Justice D.P. Chaudhary sir on the opening day. We had the quarterfinal rounds and the semi-final rounds on 17 February 2024, where we have employed a two-tier mechanism for the evaluation, wherein the judges were required to prima facie provide an esteemed recommendation of the team going forward in the advanced rounds unanimously. In case of split decision, a detailed criteria was utilized for evaluation, with the highest scoring team proceeding further. This approach maintained the quality of teams appearing before the bench and reinforced the objectives of the event. And the quarterfinal rounds and semi-final rounds has been successfully conducted, which is culminated in an exceptional final we have witnessed. Emphasizing the importance of fair competition, the competition around were adjudicated by over 40 judges, including members of the bench, the bar, academia, and representatives from renowned law firms, including Civil Amachan Mangaldas, Dua Associates, Khatan & Co., Eminence Legal, Oki Law Firm, and the esteemed Competition Commission of India himself, who has contributed to the development of the participants and has helped us in integrating technology for the furtherance of innovation and excellence. In recognition of their excellence, we'll be providing and awarding the winners a cash prize of rupees 50,000, the runners-up, the cash prize of rupees 30,000. For the best speaker, we have cash prize of rupees 5,000. For the best memorial, we have a cash prize of rupees 10,000. And for the best researcher, we have a cash prize of rupees 5,000. Looking ahead, we anticipate that the National Moot Court competition will have a profound and lasting impact on participants, fostering intellectual growth, professional development, and a deeper appreciation for the nuances of competition law. Our institution remains steadfast in its commitment to organizing similar events in the future, leveraging strategic partnerships and innovative approaches to further expand the scope and reach out of our competitions, thereby continuing to nurture and empower the next generation of legal scholars and practitioners. In closing, let us remember that the pursuit of justice is not merely a legal obligation, but a moral imperative. As we reflect on the achievements of the National Moot Court competition, let us reaffirm our commitment to upholding the principles of fairness, integrity, and equality. I extend my heartfelt gratitude to the esteemed dignitaries, the judges, all participants, sponsors, and the Immaculate Organizing Committee members and the student executives for their unwavering support and dedication, which have been instrumental in making the National Moot Court competition an incredible success. Thank you.
Thank you, ma'am, for your insightful briefs. Moving forward, we would like to extend a warm welcome to our distinguished guest of honor, Dr. Vidyadhar Maji, to share his wisdom. Thank you. Sir, please.
Chief guest of the event, Father S. Anthony SJG, my colleague from the council on the government day, Avinash Bhatte, other faculty members, my dear student friends. A very good afternoon to all of you. At the outset, I would like to extend my sincere thanks to Examen University, particularly the Law School, for organizing this Moot Court competition on competition law and making the Competition Commission of India a part of it. Really, we are thankful. You may be aware that section 49 of the Competition Act mandates the Competition Commission of India to create awareness about the provisions of the competition law and the provision of enforcement procedure, investigation procedure, and to create a competition culture in the country. Accordingly, the commission has been organizing and participating in various advocacy events, maybe seminar, lecture, stakeholder consultation, roadshow. So many things we are doing as a part of our advocacy mandates. And our participation in this event is as per the provisions of section 49 of the Act. I'm sure that this 3-day event must have given enough food for thought to many of you about the competition law. And I'm hopeful that you will be the torch bearer of competition in the country. And many of you may consider to choose in future the competition law as your career option, being it is an emerging field of corporate law. I would like to inform you that Competition Commission of India is offering internships in competition law in every month, wherein students can get exposure about competition law and its enforcement procedure. Interested students may take advantage of this program, and those who are interested may visit the website of the commission to get detailed information. Having said that, let me congratulate all the teams who participated in this football competition. Particularly, two teams made it to the final round. The performance of both the teams in the final round has been outstanding. I'm really impressed the way our young would-be lawyers are presenting their case and advancing their arguments before judges. This is a good sign for the future of our country. Since it is a competition and one has to be ahead of others for a purpose, me and my co-judge, Madam Ratha, we decided in favor of one team, considering the parameters set by the organizer. You know, one team, we cannot say that in all parameters one team is ahead of others, but overall we have to give one team, declare one team as a winner over the others. No doubt, the winning team deserves all praise. At the same time, the runner-up team should not be felt dejected. After all, it is a competition. I congratulate both the winners, would-be winners, and the runner-up. Friends, let me take this opportunity to speak a few about market regulation in India and its emerging dimension. 3 points I would like to cover on this issue. Firstly, I will talk about various facets of market regulation in India, and then I will talk about the economic philosophy of competition, and finally, I will just briefly highlight what are the provisions of the Competition Act and what are the important provisions that a common person, particularly the law student, is supposed to know. What are the important provisions of the Act? I will just take 5-6 minutes for this. Let me start with the first point: market regulation. Regulation is a sovereign activity of the government to control human and societal behavior by prescribing a set of rules having the force of law. It is to control the private behavior in a desired direction by imposing costs or prescribing undesirable behavior supported by incentives to ensure compliance. Regulation is the way through which a government can intervene in the market when it fails. There are basically two schools of thought on the genesis of regulation. One is public interest theory, we call it an AC Pigou theory, and another one is capture theory, we call it famous economist Stigler's theory. As per the public interest theory, the regulation is a response to the demand of the public for correction of inequitable and inefficient market practices. And as per capture theory, regulation is in response to the demand of interest and pressure group, those who are working in the economy, putting pressure and to get interest for their members, benefit for their members from the company. The very objective of economic regulation is to tackle the market failure. It is required to optimize public interest for maximum social welfare by balancing the free flow of market forces and the unequal bargaining power of different interest groups operating in the market. Since the sphere of government function is multidimensional, regulation can accordingly be different types. It may be economic regulation, environmental regulation, public interest regulation, and so on. And again, economic regulation may be cross-sectoral or may be sector-specific. Friends, before going to the rationale, talking about the rationale of market regulation in India, I would just like to link the economic regulation with the economic system. Broadly, the economic system of a country may be command and control system, free market economic system, or a mixed system with partly control and partly free. When you have an economy which is run through command and control system of the government or a central authority, the regulation of private behavior is managed. Conversely, in case of free market economy like ours, where all economic decisions are taken by market participants, private players, foreign players, the government has a least role to play. In such a system, regulation is sine qua non. Whereas in a mixed system, economic regulation is required in the areas that are open for private parties to operate. India adopted a mixed economic system with socialistic inclination after we got independence in 1947, wherein the government used regulation to directly control economic activities in order to spur development and protect domestic industry from foreign competition. The objective was to control economic activity directly. If you see the legislation like Monopoly Restrictive Trade Practices Act of 1969, Industries Act of 1951, Consumer Protection Act of 1986, all these regulations, Industrial Dispute Act, these were enacted with no separate regulator. It was just extended arm of the government, part of the government. Reliance on public sector for production of goods and services and a restriction on free trade had unintended consequences of operational inefficiency, poor quality of goods and services, technological backwardness, high production cost, and inefficient allocation of resources. This culminated into an economic disaster during mid-80s and 90s, early 90s, in terms of balance of payment crisis, high fiscal deficit, high current account deficit, and high capital outflow. This situation compelled the government to change its policy from a more command and control system to a more free market economy system. And the regulatory structure of India has changed actually during post-liberalization period. Recognizing that regulation and free market dynamics are both critical to growth, the purpose of a new regulatory system is to foster economic growth and protect consumer welfare by correcting inefficient market outcomes. The government recognized the need to relax economic controls and to allow the free market to operate. Minor reforms were undertaken during late 80s and then new economic policy introduced in 1991. This policy used privatization, liberalization, and globalization to stimulate growth through market forces and competition. The new system of regulation was intended to create a level playing field for public and private players and to intervene when market outcomes are not optimal. In contrast to the previous system, regulators were independent now and separate from the executive branch and enjoyed a certain degree of autonomy. The new system recognized the role of the market in economic growth and aimed to foster an enabling environment and limit potential harm to consumers and the general public. Over the past 3 decades, India has instituted various economic regulations and set up regulatory authorities so as to regulate the markets. Cross-sector regulation includes Security and Exchange Board of India, Act of 1992, the Competition Act 2002, New Companies Act 2013. Sector-specific regulation includes Telecom Regulatory and Authority Act, TRI Act 1997, Electricity Regulatory Commission Act 1998, Insurance Regulatory and Development Act 1999, Petroleum and Natural Gas Regulatory Board Act 2006, Real Estate Regulatory and Development Act 2016. And similar initiatives are envisaged for some other sectors like food, coal, and education. Of these regulations as to facilitate development of market, encourage competition, promote efficiency, and then protect consumer interests. Friends, having said the first point, let me come to my second point, that is the economic philosophy of competition. Why competition? What is the economic philosophy behind to promote competition in the market? In this regard, I would like to state that in a free market economy, competition first order importance in the field. No market economy can prosper without competition. One can say that competition is the heart and soul of market economy, and in the absence of competition, private sector tends to just rackets. Because private sector people they just want profits, and if without competition they earn huge profit, they would rather compete with each other. They will go to the golf course and play golf. So their essence is that. So competition compels them to put more efforts and they put more money for research and development. Greatness of a market economy is the hard work of the market participant, which is not possible without competition. The optimum success in a market economy comes from competition. The role of government in such an economy, then what is the role of the government then? Is to only to address when the market fails to deliver efficient outcome. And there are 4 situations where market fails to deliver efficient outcome, and these situations are information asymmetry. Suppose we are sitting in a restaurant and we do not know whether that was there in the kitchen of the restaurant. We are taking medicine from the market, we do not know whether it is a counterfeit product or not. And the role of the government is to spread information and to just eliminate information asymmetry. Externality, we do not know, industry is polluting the environment, and industry is sitting on the top of the hill and polluting the stream, and the poor fishermen are living on the ground below the hill, and just losing anything in terms of health and in terms of environment and in terms of fish cultivation, etc., etc. And the public goods provision of there are certain public goods which government supposed to do, military, judiciary, the sovereign functions. These are they cannot be provided by the private sector. And another most important thing is that for which we are here is the market power. If an enterprise enjoying a market power, then ultimately it is the government, that the Competition Commission of India, the competition authority, that has the power to eliminate, say, ensure the fair competition and eliminate anti-competitive practices. Thus, market power is one of the 4 areas where the government intervention is required. The competition can change the market power, and the competition authority can regulate the market monopoly power to ensure a free market. Further, in a healthy market economy, there should be constant openness. And be an economy or be a sector, if there is stagnation, the stagnation is not good for the economy, we all know. And be it a sector, if a particular market player is sitting in a sector over the years, then we cannot say that the sector or that economy is functioning properly. If SBI is the market leader over 50 years in our country, then we can say that the competition is not coming in the banking sector. And that happens in USSR. Stagnation over the years cannot allow the innovation to take place and the economy to grow. There should be constant openness. Disturbance, stupidity, and creative destruction should be the motto. If certain players are on the top of a sector over the years, then there is a problem. This is an indication of inefficiency. New technology should replace the old one. New players to come up, and there should not be stagnation. On competition law enforcement, I would like to mention that Competition Commission of India regulates ex post and ex ante anti-competitive conduct of enterprises. Ex post regulation include prohibition of anti-competitive agreements and abuse of dominant position by an enterprise, and ex ante competition regulation includes regulation of mergers and acquisitions, M&A, corporate mergers. The Competition Act prohibits horizontal anti-competitive agreements such as cartel, bid rigging, price determination, output limitation, market allocation, limitation of technical development, etc. Vertical agreements such as resale price maintenance, refusal to drill, tile arrangement, exclusive supply distribution agreement, etc. The Competition Act also penalizes a dominant entity when such entity abuses its dominant position in a relevant market by imposing unfair price, unfair conditions, predatory pricing, limitation of output and markets, etc. Under ex-ante regulation, the commission regulates corporate merger and acquisition. The commission has power to block a merger or allow a merger with modification when such a merger or acquisition likely to cause adverse effect on competition in markets in India. Friends, competition regulation regime is relatively new in India, which began with the enactment of Competition Act in 2002 and establishment of the Competition Commission of India in 2009. Since its inception, the Competition Commission of India has achieved modest success in enforcing the competition law provisions and making markets in India fair and competitive. Till date, more than 1,000 anti-competitive cases and more than 1,100 merger cases have been solved by the Competition Commission of India. The Commission has not only reviewed cases and imposed penalty on the erring entity pertaining to anti-competitive agreements and abuse dominance in diverse sectors, cement, tire, digital paste, stock exchange, real estate, etc., but also clear mergers within a period of 30 days, which is a matter of satisfaction. Lastly, I would like to mention that in 2023, the Government of India has amended the competition law so as to adopt the global best practices of competition law enforcement in India and to promote the ease of doing business in India. Thank you. Thank you so much for hearing me. Thank you.
Thank you, sir, for your prudent words. Proceeding with the event, we are delighted to introduce our chief guest, the Registrar of Exime University, Father S. Anthony Raj SG. We are privileged to have him here to share his profound wisdom with all in attendance. Sir, please.
Thank you, Prakriti. Respected Dr. Vidyadhar Machi, advisor in economics and head of combinations, mergers and acquisition division, Competition Commission of India. Respected Professor Dr. Avnish Bhatt, the faculty convener and the organizing secretary for the National Moot Court Competition. Faculty colleagues, esteemed judges from various law firms, dear participants from the 30 teams from across India, Ms. Ranita Jaina and the entire organizing committee of the second National Moot Court Competition, members of all the verticals within the organizing committee, friends from the media, dear sponsors, and my dear students. As we come to the end of this festival, permit me to reiterate what our chief guest of the inaugural ceremony, His Lordship, Honorable Mr. Justice Sivasankar Mishra, Judge, Sitting Judge, Odisha High Court, told all of us. Friends, we are gathered here for the valedictory ceremony. And let us remember what Honorable Mr. Justice said. In this profession, there is no winning or losing. Do the judges win? That was the second point. And your standing in the profession is as good as your brief or the memorial. And therefore, if at all you are adjudged as the best mooter, best runner-up, or the winner, the best researcher, today you emerge as a leader, and all the rest are going to be guides. So we have only leaders and guides here. And therefore, my congratulations and best wishes to all the guides first, because they are going to be there. And to the winners of the day, that they persist, that they persevere in winning. This is my fondest wish as we come to the end of the festival. And on behalf of the Exime University, we place on record the professionalism with which this entire festival has been conducted. I have heard this from the teams, from the judges. So I want to place on record that the National Moot Court Competition Committee of Xavier Law School has done it yet again. So a big round of applause for the students. The students of the Xavier Law School. And the meticulous, able guidance given by Professor Avnish Bhatt. Well, I know how, he's a perfectionist, just like many of us, just like me. Everything has to be perfect, right? We all know it, right? So, and this is the training, this is the guidance that we get, right? And the Exime University, known for its excellence and pursuit of excellence, because we set our goals very, very high, and we keep aiming for it, come what may. And therefore, my congratulations and best wishes are with the organizing committee, the entire law school, and all the participants from across India who have come. And we also place on record our gratitude to the Competition Commission of India for partnering with us. And our guest of honor, we are very proud that fellow Odia is there. And we are very proud that you are there, sir, in the Competition Commission of India. And we salute all the work that has been done by the Competition Commission of India and for partnering with us in this mega event. Dear sponsors, without you, this event would not have come through. And therefore, the student vertical, which looked after sponsorship, bringing in the sponsors and the sponsors themselves, are gratitude to you too. And what we have witnessed, as told by the faculty convener himself, this is about impact, not just the outcome, today's outcome, but rather the impact that you are going to carry, the memories that you are going to carry about the 3-day event throughout your life as you get back to your own law schools and as we get back to your normal routine. And therefore, I invoke God's blessings on each one of you as you journey back. God bless us all.
Thank you, sir, for enlightening the gathering with your judicious words.
Moving ahead, we request Dr. Avnish Bhatt to accept the momentum. We request Father Registrar to visit Dr. Avnish Bhatt. Sir, please.
We would also like to request Dr. Vidyadhar Maji to join, sir. So please.
Moving ahead, as already mentioned by our father and Dr. Avnish Bhatt, we acknowledge the invaluable contribution of our sponsors who have supported us and played a crucial role in ensuring a smooth functioning of the event and rendering it as a success. We therefore sincerely thank Manupatra for joining us as a legal tech partner and Livelog as a media partner. We sincerely appreciate the contributions made by Vishwam Jewellers Gulch, Adani Wilmer, VR Max, Sebastian Cafe, and Surya Gardens. We would also like to thank the media houses for covering the event. We invite Mr. Shantanu Kumar Patro from Vishwam Jewelers to please accept the momentum as a token of appreciation. We request our registrar and Mr. Veera Martin to accept the momentum. We have a huge round of applause, please.
Moving on, we invite Mr. Shakti Swarup Pradhan for VR Max to accept the token of appreciation. So please, we request Father Registrar Dr. Nazi and Dr. Abhi Bhatt to present the momentum certificate.
We extend a heartfelt appreciation to Ms. Ishita Jana and Ms. Gayatri Raut from the School of Computer Science and Engineering at XM University, Bhubaneswar for their commendable efforts in developing a software solution that streamlines the evaluation process of the oral comments. Proceeding further, we would like to thank Advocate Ms. Kathy Dhupal in absentia for her invaluable contributions to the proposition.
With a robust command of Indian and international laws, antitrust laws, and corporate laws, coupled with a proven track record of proficiently navigating complex legal landscapes, ma'am excels as a distinguished Indian lawyer at the helm of her independent legal practice. We are grateful for the thoughtfulness and creativity you brought to the table.
And now, the most awaited time of the event is here. It is time for the announcement of the results. A well-crafted memorial is a testament through a thorough legal analysis and persuasive writing. The recipient of the Best Memorial Award is. We request the dignitaries to please reveal the theme.
In 2, 2, 1.
And have a huge round of applause, please.
The title of Best Researcher is an accolade reserved for the individual who has demonstrated exceptional dedication and mastery of legal research. We request the dignified dignitaries to please reveal the name.
Best Researcher TC 218, Mr. Bandit Agarwal from Symbiosis Law School, Pune.
Moving on to the heart of the Moot Court, this honor is bestowed upon the participant who has exhibited exceptional advocacy skills, eloquence, and a profound understanding of the law. We are now going to announce the award for the best speaker. We request the team members of the best speaker to please
Best
receive
Speaker
the award.
Award goes to Usmi Mera from St. Xavier University, Kolkata.
We request the team members to please select the awards. moving ahead, we come to the highly anticipated titles of runner-up and winner. These titles represent the culmination of days of hard work, dedication, and resilience. So, ladies and gentlemen, brace yourselves because we are going to announce the runner-up of this prestigious event. Who is?
Yes. The runners up are PC 221.
The runners-up are from NLIU Bhopal. Can we have a huge round of applause? The runners-up have exhibited commendable skills, but it is time to announce the team that has emerged victorious in this competition. Buckle up, friends.
The winners are PC 214.
As we draw the curtains of the national football competition, all of us are truly indebted to the perseverance, hard work, and labor put in by all the organizing committee members, the faculties, and the distinguished guests. So we now like to call Ms. Rani Mukherjee, Honorary Chairperson, to deliver the vote of thanks. Ma'am, please.
Thank you. A very good afternoon, distinguished luminaries, Chief Guest Father Registrar, Guest of Honor, Dr. Vidyadhar Majhi Sir, esteemed Judge, Mr. Senior Advocate Pami Ratna, esteemed Dean, Xavier Law School, Professor Dr. Narayan Chandra Sarangi Sir, revered faculty members, the cherished participants, and our dear audience. I, Indrani Mukherjee, Chairperson of the Moot Committee, Xavier Law School, 2023 to 2024, deem it a great honor and privilege to take this opportunity to propose this vote of thanks. To our respected judges, your discernment and erudition have illuminated the corridors of justice, guiding our participants with wisdom and fairness. To the participants whose dedication, eloquence, and prowess in advocacy have illuminated the hallowed halls of our institution, we extend our heartfelt admiration. To our sponsors, whose benevolence and generosity have lent wings to our aspirations, we offer our deepest gratitude. To our notable media partners, we are deeply grateful in leveraging the power of media to inspire, inform, and unite our audience in the pursuit of our shared goals, which has been enriching to resonate far and wide. As we reflect on the triumphs and challenges of this journey, we are immensely grateful to our supporting staffs who have been the bedrock upon which the execution of this competition rested. Finally, to the organizing committee, your exceptional dedication, the countless hours of planning have been the driving force behind the seamless orchestration of this endeavor, transforming challenges into opportunities and aspirations into achievements. As we come to the end of this 3-day extravaganza, let us carry forward the spirit of candor and scholarship that has defined this gathering. May the connections forged and lessons learned continue to inspire us in our pursuit of justice and truth. Thank you, one and all.
Thank you, ma'am. Thank you everyone for being a part of the National Moot Court Competition 2024, Exam University Bhubaneswar, in collaboration with the Competition Commission of India. May you have a great day.